Okay, I think we can get started. Good morning to everyone. Welcome to today's public hearing. If you haven't done so, please rename yourself so that we can see your name. It's going to help me when calling on each speaker. And unmute yourself when you're called on, and then please mute yourself again when the next speaker is called on. As a reminder, we allow 30 minutes each speaker. Wow, that would be a few days we'd be here. 3 minutes for each speaker. Unless we ask you some questions, then it could be longer than that. But we're glad you're here. We're looking forward to hearing from you on today's agenda items. And with that, I'll call the first item. We are going to take comment on number 3, which is a proposed amendment to 6.001 and an addition of 6.009 that would establish a procedure regarding the use of restraints on a criminal defendant in court proceedings. We have one endorsed speaker on this item, Garrett Burton from SATO, and I see, Garrett, that you're in the room, so you may unmute yourself and proceed.
Yes, Your Honor, thank you. My name is Garrett Burton. I'm an assistant defender with the State Appellate Defender Office. As we wrote in our letter, the State Appellate Defender is in favor of protecting the rights of individuals who are accused or have been convicted of crimes. But as written, the proposed amendments don't go far enough to protect all of the people who appear before our trial courts. Right now, specifically, the proposed amendment isn't going to protect the rights of our clients, who will almost never appear in front of a jury while we represent them. That should change. And courts should be required, in addition to that change, to use the least restrictive means necessary to restrain clients if that's the case. And I'd like to talk about 3 reasons why. First, shackles are humiliating. I don't think there's really any way around that. They embarrass and dehumanize our clients. Oftentimes, a court appearance affords our clients really a rare opportunity to see their families outside of a prison setting. And I personally had one client who met his son for the first time in a courtroom while he was shackled. I think if the rule is amended to require the least restrictive means necessary, any dignitary harm that flows from those shackles can be mitigated. And second, other security measures are already in place for instances like this, and as a result, restraints are unnecessary. The Michigan Department of Corrections already sends 2 armed guards to escort our clients to court appearances. That's the case whether an individual has just been convicted or an individual has been ticket-free for over 25 years. Because our clients pose such a low risk, trial courts will often allow them to be unrestrained during a hearing. But what a court rule will do is it will ensure that that is oftentimes the case going forward in the future. Finally, shackles create a logistical difficulty for our clients. When they're at counsel table, individual clients need to ask questions, they need to make decisions, and they need to give input on an attorney's argument. To do that, oftentimes they've got to be able to write, and shackles don't allow that to happen. So instead, what happens is we have to whisper with our clients, and that jeopardizes the attorney-client privilege. And I know that I have, in fact, had to ask for a recess because my client was restrained and wasn't able to write, and so that we could go in the back and talk about what needed to happen at the hearing. I think for all of those reasons, Your Honor, our trial courts should consider every alternative to shackling, and they should be imposed as a matter of last resort. You know, our clients are people, and they should be treated as such. So thank you.
Thank you, Mr. Burton. Any questions for Mr. Burton?
I have one quick question. Mr. Burton, you indicated that the MDOC provides 2 armed security guards for all of your clients. But my recollection when I was a trial judge is that the MDOC would handle the transport, but once the individuals were inside of a courtroom, the MDOC would not provide security. That would be left to whatever the resources were in the local courtroom, whether it be 1 deputy or 2. Do you have a different understanding?
Yes, Your Honor. My experience has always been that those deputies who escort the clients come into the courtroom. And oftentimes what they'll tell us is they're not allowed to leave, the clients are not allowed to leave the deputy site. So,
well, wait, you're using 2 different terminology now. So the MDOC is the State Department of Corrections.
yes.
The deputies would be the local county sheriff's department. Is that what you were referring to earlier? Because you said the MDOC.
It's always been the MDOC correction guards is my understanding, who go up into the courtroom with us. It's been, now that it's been COVID, I think there's been less of an emphasis on transporting them to the jail first. and they go straight from the MDOC to our courts.
Yeah, some of that's done for financial reasons. The county sheriff stopped sending vans to state prisons because the state has an obligation to deliver those prisoners. But once again, it's just different than my understanding. It would be nice if the state would provide that level of security in all of the courtrooms across the state of Michigan, but that's not my current understanding. But thank you for your comments today.
Yes, Your Honor. Thank you.
Thank you, Mr. Burton. The next item is number 5, which is a proposed amendment to 6.201 that would require redaction of certain information contained in a police report or interrogation record before providing it to the defendant. We have 4 speakers endorsed today. The first is Jessica Zimbelman from SATO. Jessica, you may begin.
Thank you. Good morning, Your Honors. Jessica Zimbelman from the State Appellate Defender Office. I'm here on behalf of SATO and the Criminal Defense Attorneys of Michigan. I have, much like my colleague Garrett from SATO, 3 points to make about this proposed rule change. There was a proposed bill to address the Court of Appeals decision in People versus Jack. And I will first say that this is the proper venue to address changes to any proposed changes to a discovery rule, not the legislature. But when that legislation was first proposed, CDAM polled local public defender offices to see what the practices were. And about half of prosecutors' offices were already providing unredacted reports before the decision in Jack was even issued. And in those counties where the attorneys were receiving redacted reports, or unredacted reports, excuse me, the attorneys would redact them before providing them to their clients. And I think what we'll see a lot of comments from public defenders and criminal defense attorneys on this proposed rule change, because there's some disparagement of defense attorneys and our ethics going on here. You can see it in the prosecutor's comments and their reaction to providing information to attorneys. We are officers of the court. We have ethical responsibilities as well. We are not, this information is not public information. It is limited disclosures to a defense attorney so they can do their jobs. And in those counties, going back to kind of the survey we did a while ago, in the counties where the reports were unredacted, we weren't seeing rash victimization of witnesses or intimidation of witnesses. The prosecutors in their comment to this court point out a few anecdotal examples, but as the Neighborhood Defender Services pointed out, a couple examples is certainly not enough information for this court to prohibit access to defense attorney information. Our existing court rule strikes the proper balance because our clients have a Sixth Amendment right to the effective assistance of counsel. And a big part of that, as seen in this court's decisions, is the duty to investigate. We have to investigate the facts of the offense, and that is essential to our role to provide effective assistance of counsel. The existing court rule has the balance where if the prosecutor is concerned about a certain case, they can get a protective order from the court. That's what they do routinely now with defense access to child forensic interviews. And I see that I am out of time, so I made 2 points today, and I'm happy to answer any questions that any of the justices may have.
Thank you. Questions for Ms. Zimbelman? Okay, thank you for being here. I know we have you again on another item, so we'll see you in a minute.
Thank you.
The next speaker is Joan Morgan from the Macomb County Public Defender's Office. Is Joan Morgan here? Okay, let's go to Gabby Silver from the Wayne County Criminal Defense Bar Association. I think I saw Gabby. Hi, Gabby.
Good morning. Good morning, everybody. Thank you for the opportunity to speak. I am the vice president of the Wayne County Criminal Defense Bar Association. We represent over 100 criminal defense attorneys practicing primarily in Wayne County Circuit Court. And frankly, to piggyback on something Ms. Zimmelman said, I am really a little bit outraged at the notion that we as criminal defense lawyers can't protect information that could be used to put anybody in jeopardy. I can tell you that I have practiced over 35 years in this realm. I have never given a client's family discovery, nor have I ever given to a client unredacted discovery so that they can make any effort to locate a particular witness in a case like this. So we are very, very concerned about the proposed amendments to 6.201. I think that it overly burdens the system. It definitely hampers our ability to provide effective assistance of counsel. We are required to consult with prosecution witnesses. We are required to make an independent examination of facts and circumstances without the prosecutor participating. And the court has directed us through MIDC standards to do just that, to meet and interview witnesses and to do a prompt and independent investigation and evaluate whether there is even a sufficient basis for criminal charges. We are also entitled, I think, on behalf of our clients, to independence in investigating and preparing cases. To have us participate, have this amendment would eliminate the independence of our investigators, almost bringing it back to the time where we had to ask on behalf of our clients for court-appointed experts, court-appointed investigators, so that the prosecution, so that the government knew exactly what steps we were taking in investigating and preparing for trial. Even worse is the notion that we should be forced to present ourselves to a prosecutor's office where there are prosecutors and police present to allow us to investigate and to interview witnesses, which definitely, I think, based on my practice, has a chilling effect not only on the witness, but on defense counsel, certainly highlighting to the police and the prosecution the details of the steps that our investigation is taking. And again, I think to highlight something that Ms. Zimmelman also said, these situations where this unredacted discovery has caused harm to any complainant or witness are so few and far between that to make a rule to protect that is just patently unfair and conflicts with our constitutional obligations to our clients. And I'm out of time. Thank you.
Thank you, Ms. Silver. Any questions for Ms. Silver?
I do have a question. Ms. Silver, if we were to adopt this, don't you think there's a discrepancy in the discovery obligations of the state and the defense? In other words, while the defense would gain access to the personal information of prosecution witnesses through mandatory disclosures, the prosecution would not, the defense is under no similar obligation to disclose phone numbers and addresses of their witnesses. So the prosecution essentially would be required to follow the standard procedure of witness interviews provided under MCR 6.201A1, while the defense would get phone numbers and addresses automatically under this new rule. Should we be concerned about that? Is that disparity between the two sides something that we should be concerned about?
Perhaps there is a little bit of a disparity there, but the resources that the state has are far greater than the resources that we have. And I see this more as leveling the playing field and allowing us to do our constitutionally mandated job of investigating, which we are hamstringed in doing under the current amendment.
Well, I know you do a lot of work in Wayne County, and I'm from Wayne County. I'm not sure they have more resources than anyone. In any event, what are we to make of the fact that under the federal court rules, there's no blanket right to discovery of police reports, let alone the discovery of the identity of witnesses pre-trial?
Well, there is. I mean, I think that information comes a little bit later and a little bit slower. But there is providing that information is provided to us, although not at the same quickness and level that we are entitled to it in the state system. I mean, we ultimately, before trial, get everything we are entitled to receive. So I think the difference is it just comes a little bit slower.
But isn't that true of the system as we currently have it? If you want to interview a witness, the prosecution must make them available.
Again, I think I addressed that earlier. I mean, to ask us to present ourselves to a police department or to a prosecutor's office and interview the prosecution witnesses in the presence of everybody else is, I think, completely unfair. That's not going to lead to really a proper investigation or to a free an open discussion between an investigator and a witness. I mean, I've had that situation. I've had a situation where, witnesses are reluctant to really sometimes speak the truth or speak their minds in the presence of the prosecution and the police.
Okay, thank you.
Okay. Thank you, Ms. Silver. The next speaker is Jonathan Foreman. Jonathan, you may begin.
Thank you. My name is Jonathan Foreman. I'm an assistant public defender at the Ingham County Public Defender's Office here in Lansing. Wanted to start by thanking you all for the opportunity to address the court today. This is an issue that means a lot to me and to my office, as we were the litigants in the Jack case that ensured that the dictates of the court rule would be respected. Since this court denied leave in Jack last year, our office has been able to more effectively and efficiently represent our clients in all types of cases. Compliance with the court rules as interpreted by Jack isn't anywhere near 100% yet, but that decision has assisted our office as we try to uphold the promise of the Sixth Amendment and the standards of the MIDC, which were promulgated by this court. I also want to address some of the concerns raised by Pam in their written comment. Several of those concerns were raised in the Jack case. First, they asked this court to rely on anecdotal evidence, as Ms. Zimbelman noted, that people are put in harm's way if information is turned over to the defense, but there's no data to actually support their claim. We learned through the public comment process that Wayne County actually hasn't redacted information from police reports. And so I would think that if evidence existed to support their anecdotes, we would have seen it. Next, they also claim that the proposed amendment would bring the court rules into harmony with the Crime Victims' Rights Act. As I noted in my brief to Jack, the CVRA expressly provides for redaction of this information in certain contexts, but not in a discovery context. Justice Viviano, I quoted your Miller opinion in that brief. If the legislature wanted redaction of this information in discovery, it clearly knew how to make that happen. It knew how to do so. The failure of the proposed bills that Ms. Zimbelman referenced to overturn Jack, I think, proves that point, that this isn't something that the Crime Victims' Rights Act contemplates. Finally, this amendment would be detrimental to defendants' rights, and that harm is not cured by other provisions of the court rules. Pam claims that there are remedies to allow for interviewing witnesses even without their contact information, but it simply isn't the case. Only witnesses who are listed on a trial witness list, as opposed to those listed in a police report, are required to be made available for interview under the court rule under 6201A, Justice Sara. So if these are the witnesses who might be of the most, these are the witnesses who might be of most interest to a defense lawyer, those who are listed in a police report but aren't going to be called at trial. The Jack case provides a perfect example of that. There, the preliminary trial witness list was comprised of 13 names, while 19 people were listed as witnesses in the police report. There were 7 people who were listed in the police report, but not in the preliminary trial witness list. If this amendment were in place at that time, that would have been 7 people who we would have not had the contact information for, we would not have been able to speak to, we would not have been, they would not have been required to report for an interview. So after decades of an uneven playing field, defendants are finally starting to get a fair shake in Michigan, and this amendment would undo some of that progress. We're asking this court to reject that the amendment or to adopt the State Bar's recommendation alternatively. Thank you.
Thank you. Any questions for Mr. Foreman? Thank you for your comments. The next item is number 6, proposed amendment to Michigan Court Rule 7.202 that would provide a definition of governmental immunity to include a state's, a tribal government's, or a political subdivision's immunity from suit or liability. We have one speaker endorsed, Ann Sherman, the Deputy Solicitor General. Ann, you may proceed.
Good morning. Ann Sherman on behalf of the Department of Attorney General. I'll make 3 points on the proposed Rule 2021-35. First, any change that clarifies that a final order under 6A5 includes a denial of sovereign immunity, not just governmental immunity, is helpful, and we think that the proposed definition does accomplish that. Second, however, we are worried that the proposed definition could cause some confusion in that it creates an apparent conflict with the language of 6A5 because it doesn't reference employees or officials. We have that same concern with the Rules Committee's proposed definition, although we otherwise don't have concerns with their proposed amendment. We suggest a few possible fixes. The first is to define governmental immunity as immunity from suit or liability of the state, a tribal government, or a political subdivision, which is this court's proposed language, but then to add the language, including but not limited to employees, officials, and volunteers of those entities. The second possible fix is to utilize the Rules Committee's definition, and after they list state, tribal government, or political subdivision, to simply add the same language, including but not limited to employees, officials, and volunteers of those entities. A third alternative is that 6A5 itself could be amended, which actually might obviate the need for a definition of governmental immunity. And so we suggest that the court might consider in 6A5 removing the term governmental immunity, replacing it with immunity from suit or liability granted by the Constitution, state, or common law in both places where that term governmental immunity occurs in 6A5. Our third point is to address certain judges' comments that the solution of deleting 6A5 and the solution would be to delete 6A5 entirely. We think that's well outside the proposed amendment, and that would be a sea change. So if the court is considering such a change, the department would urge the court to formally propose a rule and then have separate comment on that. I think there are a lot of entities, including our department, that would want to weigh in on that important issue. Thank you.
Thank you, Ms. Sherman. Any questions for Ms. Sherman? Thank you for being here. The next item. Thank you. Next item is number 7, a proposed amendment to 7.215 that would codify the Court of Appeals practice of reissuing opinions and orders. One speaker is endorsed on this item, Jessica Zimbelman. Jessica.
Good morning again, Jessica Zimbelman from the State Appellate Defender Office. I won't belabor what's in our comment too much, but the proposed order doesn't, from our experience at SATO, doesn't actually codify what's going on at the Court of Appeals. Unfortunately, we've had a couple mistakes where we missed an application deadline to this court, and we have filed motions in the Court of Appeals to reissue the opinion to restart that clock. And that was not the fault of our clients, it was our fault. And I can think of 2 examples in the last couple of years. In one case, the Court of Appeals did reissue the opinion, in the other case, they did not. So our suggestion to actually codify practice is to make it a motion, that an attorney has to file a motion to reissue instead of a non-appealable letter. And then also to have a provision in the court rule change that allows for this motion to be filed when a deadline is missed and it's not the fault of the client. That's similar to what is reflected in MCR 6.428. And we would ask for those changes to be made and think that actually better reflects what the Court of Appeals does now. And I'm happy to answer any questions.
Any questions for Ms. Zimbelman?
Thank you.
Thank you for being here. I have a note that I was supposed to call Erin Van Kampen on item number 5. So I'm going to circle back to item number 5. Erin, I apologize. Somehow I had you added to the wrong item, and we will hear from you now. I apologize.
No, thank you very much. Erin Van Kampen, appearing on behalf of the Neighborhood Defender Service of Detroit. We submitted a pretty lengthy comment expressing our many concerns about the proposed amendment to 6201. In short, we believe it's impractical, unnecessary, raises constitutional concerns, and hinders the meaningful adversarial testing that prevents wrongful convictions and upon which our system depends. I echo the points made by Ms. Zimbelman, Ms. Silver, and Mr. Foreman loudly. So I want to try to focus on a couple of points that didn't come up in their comments. Specifically, in response to a question asked by Justice Zara, I do want to emphasize that our court rule is different than the federal rule. It does require mandatory disclosure of police reports, but that's especially important in Michigan because our Brady jurisprudence is not as developed as it is in the federal system. Our Brady jurisprudence in Michigan is it is very limited. And I would say my experience, both as an appellate defender at the State Appellate Defender Office for a number of years, and now working with NDS Detroit and the trial bar, is that prosecutors regularly overlook their obligations, specifically under Kyles v. Whitley, recognizing that their obligation extends beyond what is in their file to what is in the government's possession, including law enforcement officers. And so the court rule we have helps make up that gap in a way that is very important. That is very important for meaningful adversarial testing. And in addition to the other points that have been made by other defense attorneys in this session, I want to also address the disparity issue. The court, or the prosecutor's comments and Justice Zara have expressed concerns about the disparity in the discovery rules. I mean, those are baked into the due process rights of the accused, in part because it is the government who is accusing someone of a crime, and it is the government who bears the burden of, in a fair way, proving that person is guilty of a crime before they can be treated as a criminal and sanctioned according to law. And we have recognized in other contexts that the proper functioning of the adversary process requires access to the raw materials integral to building an effective defense. We usually see that principle come up in the context of funding and equal protection, access to funding for experts and investigators. But it's hard to imagine anything more integral to the building of a defense than access to the witnesses who are, the defense is duty bound by our federal and state constitutional jurisprudence and our standards for practice as a profession to independently interview, to locate them, to interview them. And this court has, in multiple cases, found that convictions need to be vacated because of information only in the hands of witnesses. And that information can't be obtained without contact information. I'm happy to answer any questions.
Are you taking the position then that as a matter of constitutional due process, this amendment is required?
Your Honor, I'm taking the position that as a matter of constitutional due process, this amendment would violate the rights of the accused. It would have a dramatic impact on the ability to deliver effective assistance of counsel. It would inhibit the right to confront and cross-examine the witnesses against a person accused of a crime, and it would also undermine the prosecutor's obligations under Brady.
And when you say that Michigan's Brady jurisprudence isn't as developed, I mean, Brady jurisprudence, it's a federal requirement that we all follow. Are you saying the courts aren't following it, or are you suggesting that the prosecutors aren't following the requirements of Brady?
I'm saying that in my experience, Your Honor, as a matter of practice, that there is an underappreciation for the fact that prosecutors' obligations under Brady extend beyond the information in their file to include all the information on behalf of the government. So, for example, it wasn't until 2019 that the Court of Appeals recognized that the medical examiner is considered to be part of the government for Brady purposes. And before 2019, there was even an unpublished Court of Appeals opinion that suggested the medical examiner wasn't part of the government for Brady purposes, even though they have a statutory obligation to cooperate with and assist the prosecutor in criminal cases. And so because there are, in my experience, times where prosecutors do unintentionally, I think, overlook the fact that their obligations extend to what might be in the police department's possession, information known to the police. Our discovery rule requiring mandatory disclosures of police reports plays a critical role in bridging that gap.
Thank you.
Thank you.
And I apologize again for skipping over you. Thank you for being here. Thank you for your comments.
Thank you, Your Honors.
The next item is number 8, which is a proposed amendment to 6.502 that would allow a third exception to the one and only motion rule. There is one speaker endorsed for this item, Matt Monahan from Sato. Matt, you may proceed.
Thank you, Your Honors. Good morning. Matt Monahan from Sato. In addition to what we have in our letter, I'd like to make one brief point, and that is that this proposed amendment is consistent with the spirit of our court rules. That's Rule 1105. The extra here exception to the bar on successive motions goes to the just, speedy, and economical dispatch of collateral appeals. and it rightly strikes the balance between fairness and finality. If somebody, like happened in the Owens case, if somebody has a conviction vacated in a federal collateral proceeding, but is unable through that federal collateral proceeding to obtain a resentencing in the state court, this court rule cuts right to the chase and allows that individual to turn that federal relief into an accurate and fundamentally fair sentence. Thank you, Your Honors.
Thank you very much. Any questions for Mr. Monahan? Thank you for being here and your comments.
Thank you.
The next item, number 9, is a proposed amendment to Administrative Order 2020-17 and Michigan Court Rule 4.201 that would permanently incorporate some provisions from Administrative Order 2020-17 into the court rule format. We have a lot of speakers on this item. Matthew Pallitz is the first endorsed speaker. Matt, you may proceed.
Good morning, Your Honors. My name, and may it please the court, my name is Matthew Pallitz of Pallitz Law. We are one of the largest filers of landlord-tenant cases throughout the state of Michigan. I stand by my written comments in opposition to any amendments to MCR 4.201. Further, I'm urging you to relinquish superintendent control over the lower courts. Even the president has long said that the COVID pandemic is over, and regardless of the economic turmoil and desire to intervene, separation of powers dictate the appropriate forum to redress the Michigan Summary Proceedings Act is in the legislature and not the judiciary. And while court rules may be promulgated by the Michigan Supreme Court, no procedural rule is to be inconsistent with express statutory provisions. So, for example, there is no statutory authority to allow the issuance of a stay of proceedings, a multiple hearing protocol, or mandate for personal service to obtain a possession-only judgment. As far as procedural inconsistencies, specifically with regard to the proposed revision to MCR 4.201B3C, this is duplicative in nature, as plaintiffs already have to acknowledge the premises are fit for habitability. As to the jury demand request for defendants in Rule 4.201G4, taking into context all of the proposed amendments, a defendant could initially appear without raising a defense, utilize all of these delayed procedures only to be ultimately denied for government assistance, and then at the 11th hour demand a jury trial simply to delay proceedings further. And I would consider this a weaponization of this right, which I witnessed firsthand many times during the EDP era. And this creates an undue leverage in the negotiation. With regard to the proposed amendment to MCR 4.201 G5D, all parties need to get notice of hearings. My firm regularly practices in over 70 district courts in the state, and I can tell you many times the judge will not give a next hearing date at that time on the record, and many times they will give a date only to change it in the subsequent notice that's sent in the mail. With regard to G5 as well as MCR 4.201 K1 and 2, besides what I've said earlier that these are contrary to statute, the district court simply cannot adhere to these timeframes, and my clients are being prejudiced. I represent property owners, and anyone who routinely practices in 36th District Court can attest to this. The Michigan legislature made a policy decision for prompt determination in summary proceedings to allow a property owner to be restored to possession of the property and to minimize any sums or financial harm to the defendant or tenant. Finally, with regard to K2C4, it states that a consent judgment or conditional dismissal can enter only upon judicial review and after an adequate inquiry determines the terms fair. Neither that phrase, adequate inquiry, nor fair are in the statute. So in closing, I would say that these amendments are unconstitutional, a violation of separation of powers, and adoption of these proposed amendments would constitute an abrogation of private property rights. I would hope that the enormous volume of commentary in opposition is a loud beacon that should be heard and not ignored. Sorry to go so fast. We don't have much time, and I appreciate the time. Thank you.
No problem. Thank you very much for your comments. Any questions for Mr. Pallitz?
Yeah, I just have one, Mr. Pallitz. This is Justice Viviano. My question is, you mentioned you practice in the 36th District Court, and I'm interested in the impact that the rules are having, the rules are having on the processing of cases right now. How would you assess the functioning of the landlord-tenant docket in the 36th District Court?
I would say no disrespect to the judges that practice in the 36th District Court and the staff that's clearly overwhelmed. The state of affairs in the 36th District Court and the city of Detroit is abysmal for property owners. It's really become a constructive moratorium in consideration of the prior moratoriums that were enacted during the height of the pandemic. It's taking a considerable long time to get cases processed, to get cases heard, and through the proceeding, it's just to the detriment of my clients. It's not a good situation, Your Honor.
How long does it take on average for cases to be disposed of?
On average, it's taking months. I have some cases that have literally still not been disposed of since 2020. And I think I've broken my record of 11 hearings. It's just simply put, this is an unfunded mandate, and the district courts, many district courts, cannot adhere to the administrative burden that is upon us. I will say the only saving grace and silver lining is the Zoom mandate, which I would continue to press for to be permanent. That is helpful, and I think that's pretty much the only thing landlord and tenant advocates can agree upon that's helpful, and that is helping the situation. But unfortunately, it is a state of pretty dire straits in the 36th District Court as far as private property rights and landlord and property owners' rights as well.
And I guess just not to unfairly just focus on them, has it had an adverse impact on other courts that you practice in?
It has had a tremendous adverse impact on many courts that I practice in. AO 2017, again, we don't have to wind back the clocks on that. It was during the COVID pandemic where there was a lot of uncertainty. But this notion of no sunset provision for exercising superintendent control has, in my opinion, I'm pleading with the court to please relinquish that. And as far as then trying to memorialize these provisions within the concept of the court rules, again, is contrary to the Michigan summary proceedings. And Justice Viviano, I know that you have been vocal on this with regard to that the legislature for summary proceedings was very clear. It was intended to be a streamlined process to restore property owners' rights, and trying to memorialize these terms within the court rules, in my opinion, is a violation of separation of powers. And I know that some of the justices on this panel agree with me.
Thank you, counsel.
Thank you.
Thank you again, Mr. Pellets. We appreciate you being here. Yeah. Peter Rudell is next. Peter, you may proceed.
Thank you, Your Honor. My name is Peter Rudell. I'm with Honigman. We represent the Apartment Association of Michigan. I've reviewed virtually all of the comments, as I'm sure all of you have. And it seems to me that the goal of all commenters is the same. It's to keep the residents in their home. It's just the manner in which we achieve that is where the difference occurs. We provided written comments. I'm not going to belabor the point on those written comments. I just want to highlight a few items. I would agree with the previous speaker. We support the right to Zoom and the use of Zoom in remote proceedings. We support the right to counsel. We support the information that was suggested to be added to the summons regarding housing assistance for and the opportunity for the individual, the resident, to know their right to legal aid and other things that would allow the judicial process to be open to all citizens. The second point I'd like to make is regarding the service requirements. The service requirements in the proposed rule are unchanged. It is Rule 5.201 sub D, which are the current service requirements, and all summons must comply with Rule 2.105 as well. So I won't belabor that issue, but I understand that there may be questions about the service, and it is consistent with current law. There are no proposed changes, and the service must comply with existing civil procedure service requirements. I would also concur with the comment made by Judge Kelly. Setting a second hearing for someone who has failed to appear in court after receiving a summons, posting on the door, and another mailing is a waste of the court's time. The third major point I'd like to highlight is the jury demand. Under the proposed rule, the jury demand can occur 2 days before the proposed trial. We would obviously suggest that is very late in the process and would suggest the jury demand occur earlier. As I'm sure you have read in many of the commentary on this act was adopted in 1972 by the legislature. It was a recommendation from the Michigan Law Revision Commission in 1970. After changes were made to make it more difficult for property owners to achieve or recover the possession of their property. If the court is interested, I'm sure your clerks could obtain all of the background information on why this came to be. The last point and my final point is, obviously, this is an issue that has great comment and great interest. We encourage you to continue your deliberate process, and I'm happy to participate in any manner that you all see fit. So thank you for your time.
Thank you, Mr. Riddell. That's helpful. We appreciate your comments and that offer. Thank you very much. Any questions for Mr. Riddell? Thank you for being here. Next is Matthew Miller. Matthew, you may begin.
Thank you so much for having me. Good morning. Unlike most people who are on this hearing and who have commented on this proposal, for more than 25 years, I've appeared as a lawyer in virtually every district court in the Lower Peninsula, handling a large number of landlord-tenant cases, probably litigating more cases personally during that time in sheer number than anyone else. I know from longstanding firsthand experience how these cases operate in the real world and within the law. I also serve as a legislative committee chair for the Property Management Association of Michigan, whose members operate more than 200,000 rental units of all sizes, from single-family homes to large multifamily complexes. And I could discuss these proposals for hours, but I hope that you would read my letter, the PMAM letter, and the letters written by my plaintiff attorney colleagues and the district judges. But I want to address one, maybe two false premises upon which these proposed changes are based that disagree exactly with two of the comments made by the predecessors who just spoke. First, court is easier and more efficient on Zoom. No, it's not. Anyone who thinks so hasn't handled multiple landlord-tenant cases in person and certainly doesn't handle them on Zoom. Any plaintiff attorney who might support handling these cases on Zoom either files very few cases, or by having to appear at multiple hearings, it's beneficial to the attorney's income, but it's not beneficial for the litigants. When I used to go into district courts across this state with caseloads exceeding 25 cases in each court, often many more than that, I can tell you unequivocally that a court can handle hundreds of cases in the same amount they can handle only a few on Zoom. And courts in person can be set timely in accordance with the law. Can't do that on Zoom. MCL 600.5735(2)B requires the cases are set for hearing within 10 days of filing. That law is being violated every single day in virtually every court in this state. Our office has cases we delivered to courts in June for which we still don't have hearing dates, and they haven't even been filed yet. We have courts giving us case dates in January and February for cases filed in October. This is because the courts can't schedule efficiently on Zoom. That's what the problem is. It just doesn't work. But I can go into a courthouse close to every resident's home, meet with every resident, address every issue, and resolve every case. That's something I can't do on Zoom. I want to resolve these cases. And I've never had a situation where a court has ever refused to adjourn a case because a tenant had an actual defense. The fact is, actual defenses to these cases are exceedingly rare. They just don't often occur. We should not treat every case as though there's a valid defense when there is not. And anyone who thinks that balancing multiple cases on Zoom on multiple devices at one time is something easy to do has never done it, because it's impossible. I'm asking the court to reject these proposals, all of them, and I'm happy to discuss any of them in more detail, and I appreciate the court's time today.
Thank you very much. Questions for Mr. Miller?
Mr. Miller, this is Justice Viviano. I appreciate your comment about Zoom. I do think it's beneficial in some cases, and can be. My own view is that the local judges should make those determinations, but I do hear a lot from attorneys who are happy to be able to Zoom into multiple courts on a morning and be able to handle multiple matters. But of course, I hear from the judges, the same judges, that those lawyers are not as well prepared for those hearings. I don't think the clients benefit from having lawyers less prepared, and I don't think clients are getting charged less by their lawyers who are appearing in multiple hearings. So I appreciate you, as a lawyer, mentioning that.
Thank you. I could speak further if you'd like, but I don't hear a question there.
Well, if you have more on that topic, but I just appreciate you making the point. I usually I like lawyers. I was a lawyer. I respect lawyers and the work they do, but on this topic, I don't agree when they try to tell me what the benefits are. I think in this setting, I'll tell you, I think Zoom is much more efficient. And so just like we just had the creditors bar tell us they want all their hearings on Zoom so they can more efficiently prosecute their cases. They didn't present it that way. But you know, it leaves out all the, what you just said, all the personal interaction and ability to resolve cases and look people in the eye and understand what that person's situation actually is. And for the judge to be able to make a determination whether they actually have a defense or a genuine opportunity to find some type of financing assistance.
I would just say two things. Number one, Zoom is wonderful for a motion hearing in circuit court, a hearing with lawyers. It works great when you have one matter. When you have 50 matters, it can't work because the court can't schedule 50 matters, but they can schedule 50 matters in person and can address them all efficiently in person. When you have one case in one court and one case in another court and one case in a third court, obviously you can't be three places at once. I'm asking this court to reject AO 2020-17 and these court rule changes so we can go back to appearing in bulk filings in court so we can address these cases all at once. It's better for the litigants, it's better for the courts, it's just more efficient and it complies with the law. So there's a bunch of different things going on. If we're going to continue hearing cases one case at a time, then yeah, Zoom makes sense. I'm saying we shouldn't be handling cases one case at a time. We should be handling them all at once. And you can only do that in person.
I guess you pointed out to one other thing that I've been hearing about now with the backlogs, and that is the delay in setting the initial hearing, which I don't think people are really paying much attention to because it doesn't really have anything to do with all these changes. It has more to do with what you alluded to, which is the difficulty in scheduling Zoom hearings. And so I've heard many, just as you've reported, that many courts are taking, instead of scheduling things within the 10-day period mandated by law, it's taking weeks, months, even several months to even have that initial hearing.
Yes, that's absolutely true in many, many courts across the state. And the most important thing to keep in mind with that is that in 26 years of doing this, I have found that it is virtually impossible for a resident to come up with a balance that they owe of more than 2 months rent at a time. When you're 3, 4, 5, 6 months behind, you cannot catch that rent up. If you want to see more evictions, slow down the process because frankly, when the amount is less, people can make arrangements with their landlords, they can make payments, they can get help. When they have massive balances, and I'll tell you, I've never seen a $10,000 plus balance in my life before this pandemic started. I can't tell you how many $25,000 and more judgments I have taken across this state with people who have no way of ever paying it. And that's even after Sarah paid some money. So the more there is a delay, the worse it is for residents. It's counterintuitive. Everybody thinks more time means better. It does not. As a practical matter, it does not. It's better to get them over with sooner. That reduces the debt. It will allow people to make up their payment. And remember, the only reason we're here is because the rent didn't get paid. The tenant didn't pay the rent. So to help them get it caught up, we need to get a resolution quickly so that they can get caught up and get help.
All right. Thank you, counsel.
Thank you, Judge.
Thank you very much. The next speaker is Kim Kramer from Michigan Legal Help. Kim.
Good morning, Justices, and thank you so much for the opportunity to comment on this proposed administrative order and court rule. My name is Kim Kramer, and I'm a lawyer at the Michigan Legal Help Program. We provide a website with self-help resources to help the many Michigan residents who have to face legal problems without lawyers. First, and most importantly, I would like to thank the court for its leadership on eviction and other rules during the pandemic. And we're grateful to see the court turning lessons learned during the pandemic into future best practices in eviction procedure. The modest proposed changes to eviction procedure would have a significant impact on low-income tenants who often need to represent themselves in court. I also want to briefly mention the obstacles that self-represented people face in participating in this comment process. As our written comment points out, there's a major disparity in access to lawyers between landlords and tenants. This disparity obviously impacts the legal eviction process, but it is also a systemic issue that impacts the ability to participate in notice and comment. I did not read each of the 875 comments posted as of yesterday afternoon, but based on a random sample, many of them appear to be from landlords and their lawyers. The limited tenant comments should not diminish the importance of taking tenants into account when making eviction rules. I can't cover all of our written comments on this proposed rule, so I've pulled out 2 issues of particular importance to MLH, which are remote port and the 5-day rule. So first, we generally support allowing remote proceedings in some eviction court dates, but we also think it's important for the court rules to recognize the limitations of remote court. Remote hearings are more accessible for some people, but we also know that limited internet access is an issue for some litigants and even some courts. We encourage the court to incorporate protections in situations where remote proceedings might be a barrier for some litigants. For example, the protections listed in the general remote court rule under Michigan Court Rule 2.407. Finally, we support the court's continued suspension of the 5-day rule. As you know, before the pandemic, in a dwindling number of courts, there was a 5-day rule, which in this minority of courts, landlords could file defaults if tenants did not file a written answer within 5 days of being served with an eviction complaint. Requiring a written answer before allowing tenants to appear in court is a major burden, particularly considering that most tenants do not have lawyers at this stage of the process or at all. Having, as a person who provides statewide services, also having a uniform civil procedure for something as essential as pleading requirements goes a long way toward allowing statewide resources such as Michigan Legal Help to provide accurate and understandable information at scale. Thank you again for the opportunity to comment today, and I'm happy to take any questions you might have.
Council, good morning, and thank you for being here, and thank you for the work that you do. I have a question for you on this perspective. Are you concerned that ultimately what ultimately could wind up happening is that folks that are trying to get an apartment who don't have a good credit history are going to have trouble doing so because with all these changes that are being proposed, a landlord is going to want to make sure that they're protected on the front end?
I don't think so, because this court rule is not changing the amount of rental properties in existence. The court rule is not changing the number of renters, so that supply and demand on the front end hasn't changed. It has become a lot more difficult to find an affordable apartment. We hear sometimes from visitors who have had their rent increased by as much as 60% recently. So I do have general concerns about finding housing and affordability, but my biggest concerns are not related to changes implemented by this court rule.
Okay, and you don't see the changes that are being proposed that are they're going to cause a higher expense or cost to landlords, to the extent that if I'm a small business owner and I say to myself, well, I need to limit my risk here because of this longer, more drawn out process that I'm going to have to go through, that I'm going to really make sure that I do very extensive background checks. And if there's a question, if I see a potential tenant where I say to myself, you know what, this could be a problem, but I'm willing to take a risk, but then I look at what I have to go through now if these changes come into place, you don't think that that could create a more limiting effect on people who are trying to rent apartments or first-time apartment rentals?
I do not, Justice. I just think 14 days in the scheme of things is not a very long time. And that's what we're discussing here, is a 14-day stay to allow people to find money to pay their rent. And as you know, there are many avenues landlords can use to evict a tenant. And so if they want a remedy besides getting their money, they could file one of those other types of eviction cases. But in general, I don't think a 14-day stay is unreasonable.
Counsel, thank you. Have a good day.
Thank you, Justice.
Let me just follow up. This is Justice Viviano. You said this is about a 14-day stay, but some of the earlier speakers told us that there are long backlogs and scheduling delays that run into many months in these cases. In other words, it's not just about maybe these particular changes, but the effect cumulatively of a lot of the things the court has done the last few years. is impacting this process. And so, first of all, do you agree or disagree with their observation? Are a lot of the courts sort of mired in backlogs on these cases, or do you think the system is running efficiently?
So I, of course, can't disagree with someone else's observation. As I mentioned, I provide self-help resources, so I no longer represent tenants in court. It's been about 10 years since I've done that. But I also, we can ask landlord advocates about whether or not it's difficult to get an order of eviction, but there's also court data on that. So I would encourage the courts to look at the court data on timing. Certainly that's something to address. But again, I would also say, to the extent that there are eviction cases languishing from 2020, an additional 14 days, to the extent it could help someone to get money to the landlord, does not seem to be the straw that is breaking the camel's back to me. So while I do think it is important to address these systemic scheduling issues, that as we're moving forward in Zoom to have some good statewide resources on addressing the backlog and how to schedule Zoom hearings well, I don't think that is what this court rule is about.
Thank you, Counsel.
Thank you for being here, Ms. Kramer, for your comments. We appreciate it. Next is Angela Tripp, who wears many hats, but today I think is wearing the state planning body hat.
Thank you. Good morning, Your Honor. Angela Tripp. I am in fact here with my state planning body hat on. The planning body is a forum for planning and coordinating the state's efforts to deliver civil and criminal legal services to the poor. As we reflected in our written comments, the planning body by and large supports these proposed changes to the court rules. These changes, which are in the scheme of things relatively minor, have nonetheless had a significant impact over the last 2.5 years on increasing access to justice. These changes have made the eviction process more fair and given tenants a better chance to engage in the process that has the potential to totally disrupt their lives, to appear at a hearing to tell their side of the story without first filing a written answer, to have a pretrial where they learn about and get connected to available resources, and to pause the eviction process while their application for much needed and available rental assistance is being processed. These opportunities for tenants to impact the outcomes of their cases slightly rebalances the power disparity that has long ruled eviction dockets. And the participation of these litigants is critical to ensuring our courts are making decisions based on the full set of facts. You will hear that the rule changes, which have been proven possible to implement over the last 2.5 years, have not prevented landlords from filing eviction cases or getting eviction orders. Those numbers are almost back to pre-pandemic levels. However, the rule changes have given tenants more time to take advantage of the social safety net and get the rental assistance they need to pay their past due rent and prevent homelessness. A recent return on investment study released by the Justice for All Commission calculated that for every dollar spent on legal services, including eviction prevention, there was $6.69 in immediate and long-term consequential value to the individuals served in the community as a whole. This includes savings in community support costs, reduction in community medical care expenses, savings in housing and support costs for homeless families, and savings in community law enforcement, court systems, and government agency costs. Similarly, investing in due process in eviction cases to prevent homelessness can result in the same sort of benefits for our communities. The biggest complaints about these proposed rules are the time they add to the process. Due process takes time, but this is the cornerstone of our court system. For too long, tenants have been by and large steamrolled by a system that prioritized speed above all else. Summary proceedings still exist in the vast majority of cases as fast-moving cases, especially as compared to other case types. But the proposed changes would ensure that they're handled more methodically, carefully, and consistently, leading to more just outcomes. There are also complaints that these measures would unduly burden district courts, but that is really a systems and a funding issue rather than a process issue. We have no doubt that district courts need more resources, but the trade-off for efficiency should not be a denial of a just and fair process. Just outcomes and the chance to meaningfully participate in something as important as keeping one's home leads to greater public trust in the judicial system, something that's more critical than ever right now. Thank you.
Counsel, good morning, and you do such great work. Thank you for your service to our community, and thank you for the work that you do. A question to you, though, everything has to be a balance. And as I look at this, talk to me about, we're not talking about some large corporate entity that has high-rise buildings that has many units. We're talking about, let's talk about a person that, let's say, has a second house, maybe they got it as an inheritance or whatever it is, they have a second house, or it's a small investment that they've made or a big investment to them, and they have maybe a second home, or they rent a unit in their own home or in their own building, but they're a very small business owner. They're doing the best that they can to kind of get by. And, you know, this is a significant investment for them to be able to rent a property. Let's talk about the burden that poses on them if you have a situation where a person just refuses to pay rent. Are you creating a streamlined process where ultimately you're creating a scenario for the small business owner who, like I say, has a mortgage, this is their big investment, and somebody is just choosing not to pay rent and can drag this process out for quite some time? Help me with that balance.
Sure. I don't think that the court rules as proposed necessarily result in dragging something out to a great extent. I also think that
but it does make it longer, though. It does make it a lengthier process, and you're going to set it up for a number of adjournments, and it is going to be more timely and more expensive, and it could be very cost prohibitive. Again, we're talking about the person that's renting a house or the person that's renting a unit. That individual is going to be impacted by this, are they not?
Absolutely. That individual is also running a business. You know, business owners face challenges all the time and have to learn how to overcome them and deal with the changing market to the best of their abilities. And I think even a small landlord, you know, if they can't adjust to those businesses, maybe are not, maybe that shouldn't be the business for them. I don't think that we can.
So is your position, I'm sorry, just to interrupt. So is your position then, if I'm a mom and pop and I'm a person that's just trying to rent out a house or rent out a small unit, that I need to get out of this business because I'm just not equipped to do it?
If the delay that's needed to allow the tenant to meaningfully participate in the process is something that is going to put them under, then I value due process over that. And I think these rules have really allowed tenants a better chance to participate in the process and, you know, an opportunity to get the money to landlords. And I do value that over making business easier for someone.
Okay, Council, thank you. I appreciate your comments.
Absolutely.
I just want to follow up. It's interesting because a lot of mom and pops commented without the assistance of lawyers. They found the way to do that. And they said, you're going to force us to sell our property. And so there won't be rental property. And there's already a crisis of affordable housing. It seems to me what you're also doing, even for the large landlords, is you're making it so they have to increase rents for all the other people who are paying. So of course we're seeing right now in the economy that increased rents is one of the major drivers of inflation. Does any of that concern you, or are you just sort of one dimensional focus?
I mean, the housing market does concern me. I think the housing market has been impossible for poor people for a very long time. I don't think there's been a huge change in that. I still don't think that denying people, you know, there's been a huge increase in tenant participation in landlord-tenant cases since these rules have changed. And I think there's such a value in that if that is going to drive up the housing market, then we have a much deeper problem in our housing market than court rules.
Okay, thank you.
Thanks for being here, Angela. Thanks for your comments and answers to questions. The next speaker is Caitlin Brantley. Caitlin, you may proceed.
Good morning. I appreciate having the opportunity to speak today. My name is Kate Brantley, and I am a graduate student and a researcher at the University of Michigan, where I study evictions in the city of Detroit with my colleague, Dr. Alexa Eisenberg, who will also speak today. I'm here to voice support for these proposed changes. Our recent research examines the impact of pandemic era eviction response measures on eviction filings and outcomes in the city of Detroit. So our methods include analysis of landlord-tenant case records from the 36th District Court, as well as key informant interviews with legal advocates and housing justice organizers, and regular observations of remote landlord-tenant court proceedings. So prior to the pandemic, default judgments comprised 43% of closed cases in the 36th District Court, and they have comprised 1/4 of closed cases since. So during the COVID-19 emergency, default judgments fell 44% from pre-pandemic levels. And although we cannot make causal claims attributing this solely to pandemic era changes to court procedures, our interviews with legal experts signaled that these changes contributed to a greater share of tenants accessing and participating in the courtroom. So virtual operations reduced the logistical barriers and expanded the reach of legal aid services, while pretrial hearings and the personal service requirement for default judgments at this stage provided tenants with the time and information that they needed to access unprecedented rental and legal assistance to prevent their eviction. So the caveat is that 83% of tenants evicted during the pandemic still never had their day in court. This means that despite policy improvements, default judgments remain the primary means of evicting tenants in the city of Detroit. So default judgments really illustrate how the legal eviction process obscures tenants' rights and empowers landlords. They are the consequence of systemic barriers that limit tenants' access to the courtroom. Not only do they have to overcome logistical challenges such as transportation and childcare, but their participation is often discouraged by courtroom culture as well as their past experience of injustice in the courts. With tenants unable to access court and raise defenses, landlords win their cases without strict scrutiny over whether they have the right to possession, they adhered to due process requirements, or had the standing to evict. And this is especially problematic in Detroit, where serial eviction filings persist while landlords often operate illegally and rental code is not being enforced by either the city or the court. So although these changes are made out to be extreme by the landlord industry, they are in fact quite limited and overdue. So I think these proposed changes could really promote access to the courtroom and provide tenants with additional time, information, and power in the context of our unjust housing system. So I really encourage you to adopt these changes and avoid returning to pre-pandemic conditions. Thank you.
Thank you very much, Ms. Brantley. Next is Dr. Alexa Eisenberg. Dr. Eisenberg.
Excuse me. Thank you, Your Honors, for having me today. My name is Dr. Alexa Eisenberg, and I am a postdoctoral research fellow with Poverty Solutions at the University of Michigan. And I'm also a renter living in the city of Detroit. So I'm here today to voice support for the High Court's proposed amendments to Court Rule 4.201. My research has tracked roughly 70,000 eviction court records filed in the 36th District Court since 2019. Using this data set, we have been able to analyze the impact of pandemic-era eviction response measures on eviction filings and outcomes in Detroit. Our findings and past research on eviction are relevant to the proposed amendments to the Court Rule 4.201 in several ways. As my colleague, Kate Brantley, just discussed, our findings suggest that modified court procedures have alleviated some of the systemic barriers that prevent tenants' access to the courtroom and increased access to legal aid. As Kate made clear, the proportion of closed cases ending in a default judgment has fallen 44%, which is a lot. Pre-trial hearings, the personal service requirement for immediate default judgments, and stays for cases seeking rental assistance can better ensure that cases will be decided based on their merit and increases likelihood that landlords will behave their rent, thus benefiting the public at large. Our findings indicate that larger changes are needed to protect tenants who live in properties that do not comply with basic health and safety codes. The legal relationship between a landlord and tenant is a two-way obligation. And right now we have a system where the court is enforcing laws about tenants' obligation to pay rent while not enforcing those for the landlord's obligation to keep rental properties safe and habitable. It privileges one party's rights over the other. My past research shows that children living in low-income renter households are not only at the highest risk of eviction, but also for lead poisoning. The current complaint form for the court allows landlords to easily make false claims of habitability, and our research finds that 9 in every 10 eviction case filed in Detroit is done so by a landlord who is not compliant with local health and safety laws. Contrary to what the landlord lobby is saying, the proposed court rules do not significantly alter the summary eviction process. Evictions will still proceed far faster than any other court cases and far too fast for many tenants to know their rights or access relief. Pre-pandemic, the summary eviction process took just 27 days. 71,000 tenants faced eviction each year. 4 in 10 were evicted by default. 4% had access to an attorney, and 60 were forcibly evicted by a bailiff each day. This is an unacceptable status quo. And I appreciate the previous comment of tenants whose lives who are most impacted by these court rule changes do not have the resources, procedural knowledge, or lobby to combat the pecuniary interest in the real estate interests, pecuniary interest in this matter. But the consequences for their families and their lives are extremely grave, which we know from extensive research showing that eviction disrupts communities, precipitates job loss and homelessness, and leads to overcrowded, poor quality housing. In sum, our evidence indicates that tens of thousands of evictions in Michigan could be avoided each year if the court enforced codes and tenants had the opportunity to raise defenses, access assistance, or assert their right to an attorney. I urge you to adopt these changes.
Thank you very much, Dr. Eisenberg. We appreciate your being here and telling us about your research. The next speaker is Tora Brown. Tora, you may unmute yourself and proceed.
Thank you. My name is Tara Brown. I am with Detroit Eviction Defense. I am not an attorney. I'm not a researcher. I am just a Michigander and one of the many Michiganders that is facing eviction. I'm also a licensed real estate agent and a former property manager. I'm not being evicted for financial reasons. I'm being evicted for retaliatory reasons. I was involved in the Cass Community Social Services tiny home scam. I was told I'd be a homeowner only to find out that I'm a renter. And now I'm facing eviction for speaking up about inconsistencies and downright lies. Landlords and attorneys in this state have gotten together to organize to fight these proposed changes and to fight to essentially keep their foots on the necks of tenants as they continue to be out of compliance with local city ordinances and laws. Being a landlord is a business. Would you be okay with eating at a restaurant knowing that they were out of compliance with city ordinances and law? Do we not expect local businesses to be in compliance with the laws and ordinances? So why would we not expect and require a business providing shelter to people to be in compliance with the most basic of laws and ordinances? That makes no sense. Further, to speak to the change with regard to MCR 4.201L, many landlords are already staying evictions while waiting for rental assistance payments from state emergency relief through the Department of Health and Human Services, payments from nonprofits, insurance companies, 401ks, and even relatives. These proposed changes do not go far enough to give tenants more time and information during an unprecedented housing crisis. Also, it should be noted, 92% of the landlords in 36 that are coming through the city of Detroit through 36 District Court are out of compliance. The rental code is not being enforced by the city of Detroit or by the 36 District Court. So these bare minimum protections for tenants are not asking a lot. And it's not things that can't be done. All these landlords and all of their attorneys are coming here talking about how their businesses are being impacted. People's lives are being impacted. When you are evicted from a home, you have a hard time finding another one. And some of these people, as you'll find out if you do any research in Wayne County, are being evicted only to have to go to homeless shelters. Some of them are even sleeping in their cars with their children and their families. There is a large body of evidence that links eviction and substandard housing to a range of adverse health outcomes that disproportionately burden renters of color, like Black women. Black men are locked out, or Black men are locked up, Black women are locked out. We are evicted more than anybody else. And nobody comes to our rescue and nobody defends us. And we can't even rely on the courts to defend us. And as far as speaking to that jury demand, in my eviction, I did request a jury demand and it was totally disregarded by the 36th District Court. Please adopt these proposed changes. Thank you.
Thank you very much, Ms. Brown. Thank you for being here and for your comments. The next speaker is Justin Smith. Justin, you may unmute and begin.
Very much. I very much appreciate the opportunity to speak to the court panel today. I've been practicing landlord tenant law for 30 years, and it's absolutely critical that everyone be heard on these proposed rule changes. They're very serious. I wanted to, there's been some very eloquent discussion by commentators prior to me. So I'm going to go a little bit off script here and perhaps focus now on one of the questions that Justice Viviano posed to, I think, the first speaker, Mr. Pallets. And that issue was, what is the effect of the proposed adjournments that might be occasioned by the court rule as proposed? I will tell you that that my caseload, the duration, is really extended about 500% at a minimum. The duration that has been in effect, frankly, at the 36th District Court, which is the primary court that I practice. So that is very problematic from the standpoint of the fact that whenever someone is in place in a rental unit as a tenant or an occupant, oftentimes the court doesn't consider escrow orders. When I've asked, as well as many of my colleagues have asked, Judge, can we please get a reasonable rent amount that can be put in escrow while this case gets put off from October until Groundhog Day? And by the way, that did happen. I was in court in late October, and the first adjournment for a pretrial went from October until February 2nd. And the judges just pretty much have dismissed a lot of my brother and sister counsel and saying that, Mr. Smith, we're in a pandemic. I was basically chastised. And that's some of the flavor that unfortunately I've been dealing with a lot of these cases that I've been dealing with in court. I would support Justice Viviano's dissent on the proposed amendments. I find it highly problematic that there's a requirement for personal service, and that would be a further basis for a delay. In many cases, a delay that could last 4 or 5 months. There are just so many delays that are built into this process, particularly in the 36th District Court, that I really have a problem with how this is going. There's been moratoriums, and this is tantamount to an administrative moratorium that will deprive my client base, landlords and investors, with the right to basically process cases in an efficient manner. I had a script here. I'm not going to go into it. I'm out of time. I would be open to any questions.
So I have a question for you. It's interesting because as a blind person, I prefer to rent just because it's easier. And when you have a disability, when you're a renter, especially if you have a good landlord, it makes life a little easier. You can be more independent because for people with disabilities, that ability to have someone take care of, the external parts of the unit or the apartment just tends to make life much easier. The reason I bring that up is I've been a renter for over 25 years for those ascribed reasons of just the fact that it's just easier as a blind person to not have to do that type of maintenance. But one of the biggest challenges that arises, as any long-term renter will say, and we haven't gotten into this, I'd like you to discuss it, is what can destroy a nice living experience is when you have a problem tenant. And I'll just give you examples of a problem tenant. A problem tenant is someone that just blasts music nonstop, all day, all night. You're just going to hear music all day, all night. And people on the floor, everyone in that building is horribly inconvenienced. And basically it affects your entire quality of life. if you could address the issue that arises when you have a problem tenant, when you have a tenant that basically says the rules don't apply to me, I'm going to blast my music no matter who cares, no matter what complaints I get, no matter what the neighbors say, I'm just going to act this way and I'm going to make life miserable for everybody on this floor because I can. And I think that, I'd like you to address that situation for the innocent tenants that do everything that they're supposed to do, that want a good quality of life. Could these rules ultimately make this a real problem for the tenant that just wants to live in a quiet place, have a nice place to come back to, and is now faced with a problem tenant who basically says, I'm going to do what I want. I'm going to make life miserable for everybody on this floor. It doesn't matter to me because there's nothing the landlord could do or anyone can do to stop me.
Judge, thank you for the question. And by the way, I have to tell you that it's just an honor for me to address a question that you asked. I happen to be an investor myself. I'm not just a landlord attorney. And I also worked in public housing as a senior manager for Section 8. So I do come in, I think, respectfully and without fluffing myself too much, uniquely into this discussion with the ability to balance the concerns of both landlord, the stakeholders, the investors, and also the tenants. I will tell you that in practice, Judge, if there's a situation even more egregious than what you're suggesting is the hypothetical, that there might be someone that's making too much noise, there are other situations even more so than that, where there's gunplay, there's violence. And when I go into the 36th District Court, I can do the best that I can do with writing with a Sharpie pen on my filing that this is an emergency situation, and it does not get any expedited service. I'm telling you, it's problematic. So it not only is the landlord stakeholder and the investors impacted, but of course, you're right, absolutely, that there are other people in the community that are not getting redressed by the adjournments that are given out like candy, unfortunately. And these things just get kicked down the road, potentially 6 months, even as much as we try, Judge, as much as we try. This has been going on for a couple of years now. And I won't rehash history, but it's just a problem. And whenever I see some of these, and by the way, I have to address one other issue. Every single court that I've ever gone into within the last 2 years, there's been a legal aid attorney present for any tenant that wants it. All they need to do is show up in court. So as much as we hear about people not getting service and not appearing in court, not having resources, just show up in court, and then the judges will do their jobs. The judges will hear from landlords, the judges will hear from tenants. These are not difficult cases in many cases. The Summary Proceedings Act was made to expedite things because, frankly, the judiciary and the legislature recognize that cases can be disposed of in the landlord-tenant realm pretty quickly if anyone just shows up in court. That's one of my major concerns about is having delays based on the fact that someone's not personally served, because frankly, the scale forms that were designed by the Supreme Court Administrative Office have disclosures on there that say that here's how to get legal advice. Those are mailed, those are process served. There's 3 types of service that one can get. So to your question, and I've beaten a dead horse, Judge, is both landlords, the investors, and people in the community are having a disservice upon them by having these delays. And so, and I really do try. I represent my clients. I try and put on the pleadings. This is an emergency. There's gunplay. There's loud noise. There's dogs. There's pit bulls. I own pit bulls, by the way, so I won't belabor that one. But nonetheless, that's all I have to say about that, judges, is this process, at least initially, was designed to be streamlined. Thank goodness that we are beyond a lot of the concerns with lockdowns and inability to get jobs. Now there's job postings everywhere. People can work extra jobs. Here I am sitting in a law office. Okay, I have a good life. I'm not diminishing the fact that there are tenants that have more problems than I have, believe me, but just show up in court, let's not have extra delays. I think that there are too many delays that are built in by just having someone come into court and say some magic words about how they're seeking funding or they didn't get served. They can just appear in court and be represented by legal counsel, and we can hash it out. And in most cases, landlords and tenants can agree to work out a payment plan or something.
Thank you, Mr. Smith. We just have a lot of speakers. Thank you very much for your
I'm
comments.
sorry.
For
I'm
being
sorry.
here. Thank you so much. Next is Mira Edmonds. Mira, you may proceed.
Thank you. My name is Mira Edmonds. I'm a clinical assistant professor at the University of Michigan Law School. I teach in the Civil Criminal Litigation Clinic, where I supervise law students representing tenants in eviction proceedings. I'm here today to urge the Supreme Court to adopt the proposed amendments to MCR 4.201 with the tweaks suggested in the written comment submitted by the Michigan Poverty Law Program. The basic truth about evictions is that summary proceedings do move at a pace that far outstrips the ability of a tenant at the bottom end of the rental market to find a new home. Contrary to what landlords' attorneys have represented, evictions are happening. Yes, there were delays over the last 2 years to a significant extent because of delays processing SARA funding requests, at the end of which I would like to highlight the landlords got paid. They were not left holding the bag. But when external funding is not available or not sufficient, the timing of summary proceedings works to the detriment of tenants. Time and time again, we have clients who, even with legal representation, and I would note that many clients, many tenants are not able to get legal representation. Even if they're able to get one-off advice from legal services, the supply of counsel simply does not meet the demand. Even with legal representation, our clients are often forced to move out in order to avoid a judgment and writ of eviction before they have another home lined up. As Justice Bernstein alluded to earlier, many of our clients have eviction records and they have poor credit scores, and that makes it difficult for them to get approved for new housing. That is already a problem. Background checks are already standard, so the proposed rule changes will not create that issue, and I do not believe it will even exacerbate it. In addition, application fees often run $50 to $75 and are non-refundable. So our clients often only apply for one unit at a time to avoid spending money that they don't have for units that they will not be approved to rent. As a result, our clients often go further into debt by staying at hotels for days or weeks on end while also paying storage costs for their belongings, or they send their kids to stay with family, often far away, while they themselves couch surf or live out of their cars so that they can continue to get to work and avoid going deeper into the hole. This has happened to our clients over the last 2 years. I am speaking about clients that we've actually represented. In short, they're rendered homeless, whether for days, weeks, or months, because it takes time to apply for apartments and the legal process moves much faster. It's disruptive and it's traumatizing for these families, particularly for the children. Now, the fundamental problem is that there's not enough affordable housing to meet the need in Washtenaw County, where I live and practice, in Michigan, or in the country as a whole. That is an enormous problem that requires myriad solutions from the federal level down to the local, and it's far beyond the purview of this court. The proposed amendments to MCR 4.201 are modest but important. They do not tip the balance disproportionately toward tenants. They will not prevent all evictions, and they do not go beyond the scope of the court's authority. All they do is make it slightly easier for tenants to assert and litigate valid defenses to eviction actions, where, for example, the landlord has failed to maintain basic conditions of habitability in the unit, or the landlord has violated the tenant's limited procedural rights. I see that my time is up, and I know you have lots of speakers, so I'll just end with urging the court to please adopt these amendments.
Thank you, Ms. Edmonds. Thank you for being here. Next, we have Ashley Lowe from Lakeshore Legal Aid.
Thank you, Madam Chief Justice and the Justices of the Supreme Court. I appreciate the opportunity to speak today. I'm Ashley Lowe. I'm the Chief Executive Officer at Lakeshore Legal Aid, and we are the largest civil legal aid program in Michigan, serving the Detroit metro region. And we also operate a statewide hotline known as the Counsel and Advocacy Law Line, or CALL. As part of a partnership with other legal aid providers in the state, CALL gives advice and brief service, pro se support, and referrals to people who are low income and seniors throughout the whole state. Since the beginning of the pandemic, our attorneys have talked to over 31,000 tenants who are facing eviction and other housing issues. Most of those callers were tenants looking for help with eviction based on non-payment, and many of them were living in extensive repair and habitability issues. We know that most tenants don't fully understand their rights and have no idea how to navigate the legal system without an attorney. They're calling us in a crisis. They're facing an eviction that could lead them to lose their job, lose the support from their neighbors, change their children's school, and create mental health problems. Including information about financial and legal resources in the summons as proposed in Section C will help tenants connect to rental assistance and legal representation before their first hearing, and that rental assistant might be enough to pay the landlord and resolve their matter before the next trial date. And the legal advice and representation help level that playing field in a proceeding that could be life-changing for a tenant. Lakeshore also supports the amendment to Section K requiring courts to verbally inform tenants of their right to counsel at pretrials. And we encourage courts to give more information about how to contact legal aid in case we're not there on the dockets, which we're not in many cases, and ensuring that tenants are fully aware of their rights and how to enforce them. Some tenants facing the trauma of eviction, a verbal reminder is what they really need to understand what's happening. And finally, we fully support the amendments to Section F, making video conferencing presumed for pretrial hearings. As a legal aid attorney, I talk all the time about the justice gap, the difference in the need for legal services for low-income people and the attorneys available to help them. This presumption is one concrete way to reduce that gap. The ability to appear in courts remotely has dramatically changed our ability to serve clients. In 2021, our attorneys were able to represent 50% more clients than they did pre-COVID. Last year, we helped over 7,000 tenants facing eviction on over 44 dockets, keeping more than 17,000 individuals in their homes. In courts that remain virtual, we can still advise all the tenants who qualify and want advice. But in those courts that we're not, we only can see a handful of tenants. And because of the virtual hearings required by the administrative order, more low-income people are coming to court. Default rates have dropped because tenants don't have to find childcare or beg for a ride to get to court or take a day off work to attend a 15-minute hearing. And because tenants are more aware of the resources, they're much more often represented by an attorney. Their voices are heard, their issues are clearly presented to the court, and their cases are fairly resolved. And that's what access to justice looks like. So I urge the court to adopt these proposed changes.
Thank you very much, Ms. Lowe. Thank you for being here. Next is Jim Shaftsma from the Michigan Poverty Law Program. Jim.
Good morning, Justices, and thanks for this chance to comment on the proposed changes and also my written comments earlier. And I'll speak to just a few of the points made in those written comments. As you've heard from others, the proposed changes are significant but modest, not a sweeping or process transforming change as has been characterized by some. In case process terms, they would amount to a 1-week adjournment in many cases and a longer adjournment in some non-payment of rent cases to facilitate the payment of rental assistance to the landlord. I urge the court to remember that non-payment of rent cases are pay-to-stay cases, and their primary purpose is remedial, for the landlord to recover the rent it's legally entitled to and the tenant to stay, or in the lesser alternative, for a landlord to recover possession of the property. The proposed changes effectuate that statutory purpose. Adopting these changes is well within the court's authority, first under its general superintending control under the Michigan Constitution, and then under the summary proceedings eviction statute itself. In disputing the court's authority to make these changes, numerous written comments said that the proposed changes violate the directive of that statute, section 5735, subsection 6, that a summary proceeding be heard within 7 days after the tenant defendant's appearance or trial day. What those comments, I think, uniformly and conveniently ignore is the first phrase of that provision, except as otherwise provided by court rule. In enacting this provision, the legislature was clearly deferring to the court on this issue, which I contend was a recognition of the judiciary's power over this issue. I feel compelled to respond to another common refrain of the written comments, that these changes will allow deadbeat tenants to live rent-free. Yes, that outcome would and does occur in some cases, but I contend that in a high majority of cases, tenants want to pay their rent and retain their housing, but for so many of them, as you've heard from some others, a severe income-rent mismatch too often makes it difficult for them to do so. And when a financial life event occurs, such as a necessary car repair, it only makes it harder for tenants. According to HUD data, there are areas in each of the Detroit, Grand Rapids, and Ann Arbor metropolitan areas where to afford an average rent for a 2-bedroom apartment, not including utilities, requires a renter to earn more than $35 an hour. That number reflects rising rents, and I'll quickly add that rents are rising everywhere, including in places where there are much more tenant-friendly eviction processes. So the number reflects those rising rents and the undersupply of affordable housing in the housing market. So landlords aren't primarily responsible for that huge undersupply, but they do bear some responsibility for that market dysfunction. And I realize I'm at time and its consequence, and it's not improper for the court to slightly consider and account for the very harsh realities of that market or the catastrophic impact of evictions on families, not to mention their communities. Thank you.
Thank you, Jim. Thank you for being here. Next is Judge Mike Carpenter from the Michigan District Judges Association. Judge Carpenter.
Thank you, Justices, for this opportunity to speak. I am the District Judge for Midland County and serve as the Vice President of the Michigan District Judges Association, and have been asked to speak in opposition to the current proposed changes to MCR 4.210. We would first like to acknowledge the difficult task you have of managing rules that allow for standard practices that provide for fair, understandable, and predictable outcomes for litigants and lawyers in our state. However, the issues that impact Wayne, Ingham, and Macomb are not necessarily a problem for Wexford, Isabella, or Midland, and vice versa. That's why discretion is so important, because the judges know their communities and their needs best. The proposed change requiring a mandatory adjournment at the first hearing reduces discretion of judges to grant relief to a litigant, even if the facts support that it would be the just and right thing to do. We believe that the current rule provides adequate discretion for a judge who does believe an adjournment is appropriate, even multiple adjournments. The proposed changes will have a significant impact on the workload for district courts and their staff. The requirement for an initial adjournment will at least double the number of hearings needed to manage the landlord-tenant docket. And this increase in the number of hearings will have to compete against increased workload already currently impacting district courts by recent changes. For example, changes to the bond and probation violation procedures have added additional hearings. Some are required to be heard in as few as 2 hours' notice. The clean slate legislation has caused an additional motions to set aside convictions, and because the Attorney General's office has been unable to keep up with the demand, many of the hearings have to be rescheduled multiple times, which requires staff to manage, schedule, and input data accordingly. The MIDC standards that have increased the number of hearings needed to adjudicate criminal cases because pleas are now rarely taken at arraignment, and there have been increases in the request for bond modification hearings. The time it will take to read the new informational requirements will add approximately 3 minutes to each case, which will in turn reduce the number of cases that can be done on any particular day. And the new jury trial request process will likely further strain the data entry workload and already full dockets. Requiring the judge to read what equates to a tenant's Bill of Rights creates an appearance that judges are not neutral and detached, but instead favor the tenant. The extra attorney fees incurred by represented plaintiffs by the mandatory adjournment would be an additional cost that they have to absorb, which would further exacerbate this belief. Now, we don't want to be an organization that provides problems for every solution, so here are some suggestions we think that could address some of our concerns. Make the initial adjournment discretionary, not mandatory, or provide an option for plaintiffs to provide proof of abandonment or other impossibility that the defendant will not be able to comply with the judgment and allow for a single hearing. If the first hearing must be mandatory and adjourned, it's ministerial in nature, so why not allow non-judicial officers to provide? Finally, require the summons to include the warnings and or protections, or allow for the use of vice of rights form. We use those in criminal cases, and they seem sufficient. These are some of the things and concerns that we have. Thank you for your opportunity to address our concerns.
Thank you, Judge. Thank you for being here. We appreciate your input. Next is Gary Gordon. Gary, you may proceed.
Thank you, Your Honor. And thank you for your patience this morning. I'm with Dykema, and I'm appearing on behalf of the Michigan Manufactured Housing Association. That association has 600 members, or over 600 members, who provide manufactured homes at an affordable alternative to other residential options in Michigan. The association's members own homes, they own communities in which Michigan's low-income residents may safely and economically reside. The association, through its president, John Lindley, has already filed written comments, but I would like to, in opposition to the rule change, but I'd like to highlight a couple of points. First, the association notes, as has the Apartment Association and various others, that the rule will have a negative impact on the availability of affordable housing in Michigan. Second, the rule will impair members' property rights because the rule allows use of their property for an extended period without compensation. Because the rule's operation will cause delay in recovering the property, outstanding rents will continue to mount. It's unlikely that when the property is finally recovered, there will be any payment of the accrued amount, thereby further harming the association's members. And also, as Mr. Miller noted earlier this morning, will acts as a harm to the tenants, because the longer the delay, the less likely the tenant is going to be able to afford the back rent. The association shares the same view as many others regarding the availability of affordable Michigan housing. We've heard that over and over this morning. Numerous association members have long wait lists of prospective residents seeking the affordable housing that they offer, but at the same time, the amount of available housing is reduced because the members are and will be required to carry many people living in the community rent-free for an extended period due to the lengthy time required by the proposed rules of eviction procedure. Michigan has an affordable housing crisis. Manufactured housing can help to resolve that crisis, but it cannot do so if it continues to carry residents in homes without paying, while it is unable to afford the opportunity to others to engage in that residence. There are other impacts on the members. Like many small businesses, and I think Justice Bernstein and Justice Viviano addressed this, the members depend on income. And in this instance, rental income to pay employees, pay for snow removal, trash services, and to pay their own mortgages. The extreme delay in the eviction process clearly has a ripple effect for everyone associated with these communities, including the business owners and the tenants. I see my time has expired. I thank you for the opportunity to do this. We have suggested a number of minor amendments to the rule, and that with the court's indulgence would propose submitting that to the court. Thank you.
Thank you very much. We look forward to receiving that. Thanks for being here. Next is Karen Jopkes from Legal Aid of Western Michigan, and I apologize as I botched your name. Please correct me.
We're very close. Good morning, and may it please the court. I am Karen Jopkes. I am the Director of Litigation at Legal Aid of Western Michigan, which covers 17 counties in Southwest Michigan, from offices based in the cities of Grand Rapids, Kalamazoo, Muskegon, Holland, and St. Joseph. I've been a legal services attorney for 22 years, and I've represented thousands of clients. While I represent almost exclusively tenants, I have also represented the occasional plaintiff, which was a very different experience and showed me the inequality for different parties in accessing the court system and summary proceedings. One thing we are particularly proud of at Legal Aid of Western Michigan is that our program was involved in the development of what was likely the first eviction diversion program in the state of Michigan, if not the nation. It created a win-win-win situation for all involved. This is the model that has been replicated across the nation, and is also the model that served as the basis for modifying eviction proceedings in the midst of the COVID-19 pandemic in the summer of 2020. The model was not without its problems, though. For example, oftentimes the tenants and landlords would hear about the program for the first time at court, leaving little time to get everyone connected and assess the case. And with a judgment entered at the first hearing, and with only 10 days until an order of eviction could be entered. Too often, the timing didn't work. The procedural changes made by AO 2020-17, many of which are the basis for the proposed court rule changes, were tested in the real world, and the data shows us the changes resulted in real access to the system for many litigants,
is evidenced by decreased default rates and increased dismissals. The data also shows us that filing rates are back to about where they were pre-pandemic. The landlords have access to the system. The proposed court rules will keep these procedural changes that have made summary proceedings more accessible to litigants and have supported the wide-scale development of eviction diversion programming across the state, allowing us to resolve these cases for the benefit of everybody involved. We support the court rule change to prohibit entry of default absent some specific circumstances at the first hearing. In fast-moving cases, this gives everyone time to make sure everyone is on notice of the proceedings and has access to the process. We also support the mandatory pretrial hearing. Tenants are rarely represented by counsel in landlord-tenant proceedings, and a significant number of landlords are also underrepresented. The pretrial hearing allows the court to inform both parties of their rights and allows them to make informed decisions on how to proceed. Additionally, we support requiring courts to give a 7-day notice of the trial after that prior trial hearing to give better consistency among court and to strike an appropriate balance between a summary proceeding to give the landlord possession or a resolution quickly, but also to give the tenants the necessary time on short notice to consult with legal counsel and to develop a plan of how to proceed. We also support the amendments that would give a stay of a very short period of time, only about 14 days, to allow tenants to access resources, including assistance, legal services, and to get those things to work out.
Counsel, I don't know if you can see the clock. The clock has gone to my second Zoom screen.
Yes, I apologize. The clock did disappear.
Yeah.
But for all of these reasons, we do request that the court do adopt the court rules as proposed.
Thank you very much. I'm going to ask that the hardworking and talented team at MJI who's staffing our Zoom hearing to see if you can move the clock back to the first page so speakers can keep track of their time. I will go back and forth until then, but the next speaker is Kenneth Benoki. Kenneth, you may proceed.
Thank you very much. I am the Director of Legal Services of Northern Michigan. The rest of the state, I guess, you draw a line from underneath Cadillac and we represent everything above that line. We have 36 counties in our district. We have 36 district courts and we have 12 attorneys when fully staffed. To be able to represent tenants in these hearings, we need two things. We need remote access and we need time. These court rules help us provide that. Without those two items, we would have been able to represent a third or less of the tenants that we've represented in the last 2 years. They are extremely important. Our area is vast. We cannot do 100 cases in a day. We cannot sit in a courtroom to provide a legal aid attorney in every courtroom in the state or in our district. So if we want access to justice for people with lesser means in the north, the two things that are critical are remote access and time. The particular 5-day rule I want to address, it makes it literally impossible for me to assign an attorney to a case. There just isn't sufficient time. The attorneys in my program are all generalists. They all do other things. They have many divorce cases where there's a violence involved. They have benefits cases. They have everything. So again, I want to reiterate, we need time and we need remote access. Without that, the tenants aren't going to get represented. There are no other firms up here. There is no pro bono service. There is nothing for those people. The idea that every tenant in an eviction process has an attorney that was mentioned is not possible. It doesn't happen. It's rhetoric. The idea that the system is 500% longer than it was before would mean 125 years to get a hearing. we're hearing a lot of rhetoric that is not factual. And so there's so many things. I just want to reiterate, time and access is what our program needs in order for us to represent tenants.
Thank you very much. The clock is still on the second Zoom screen for me, still hoping the team can get it moved back to the first, but I will do my best to keep watching. Thank you for being here. Next is Emily Calabrese. Emily.
Thank you. I am Emily Calabrese, and I am here on behalf of the Legal Services Association of Michigan, or LSAM, which is a nonprofit organization comprised of the 12 largest legal aid organizations in Michigan. LSAM supports the proposed amendments to MCR 4.201 and Administrative Order 2020-17. Since July of 2021, the organizations of LSAM have advised on or represented tenants in over 17,000 cases, and as such have extensive experience with eviction cases. LSAM organizations also did this work prior to the pandemic, and we have witnessed firsthand the expansion in the access to justice provided by Administrative Order 2020-17. LSAM submitted detailed written comments in support of those proposed amendments, and here today I would like to highlight the importance of giving tenants time to get connected with legal and financial resources as provided in the proposed amendments to MCR 4.201C and K. The proposed amendments to MCR 4.201C requiring written information regarding the availability of legal and rental assistance attached to the summons will allow tenants to access legal and financial support as soon as possible, increasing the likelihood of success in obtaining rental assistance and legal representation. While current rental assistance programs are changing and may not be as generous as pandemic programs, financial assistance is still available, and tenants should apply as early in the process as possible so they can give the landlords the money that they are owed. From experience, the written provision of resources with the summons will not benefit everyone for a variety of reasons. Adopting the proposed amendment to MCR 4.201K to preserve the pretrial hearing and delay trial for at least 7 days will also provide tenants time to apply for rental assistance or obtain legal advice. Legal advice which may be that there are no defenses to the eviction and payment of rent is the only thing that will resolve the case favorably for the tenant. Prior to the pandemic, a tenant could walk into court for their first scheduled hearing and receive a judgment to pay their balance or move out in 10 days. What we saw were people who did not have time to apply for rental assistance. Instead, they spent those 10 days making exhausting and difficult decisions, deciding where they would move, which possessions they could pack and which had to be left behind, applying for new jobs since they would no longer be within walking distance to their income source, and getting their children enrolled in new schools and prepared for the unknown. An adjournment of the trial date will give tenants some extra time needed to manage their legal issues and options surrounding their basic human right to housing. Giving tenants the access to resources in advance of a trial reduces default rates, increases tenant participation, allows rental assistance to be issued, and expands tenants' dignified access to justice. Thank you.
Thank you very much. Next is Shannon Lucas.
Good morning, and thank you for the opportunity to speak this morning. My name is Shannon Lucas. I'm the Director of Advocacy at the Michigan Advocacy Program and Legal Services of South Central Michigan. We provide free legal services to low-income residents in 13 counties in Southeast Michigan. We have offices in Monroe, Jackson, Battle Creek, Ypsilanti, and Lansing. We operate eviction diversion programs in all of our counties and have attorneys present either via Zoom or in person in cases or in dockets 2 to 3 days per week. We have seen these changes in action and want to support the modifications and amendments that are being proposed today. These changes have allowed our offices to provide unprecedented levels of representation to low-income residents while keeping eviction cases moving through the courts. And I want to take a minute to just express that I do believe having these amendments in place allows our attorneys to be more participatory and tenants to be more participatory in these cases, and also create efficiencies. We are there to give advice to tenants right there, and we are there to hook them up with resources that will allow landlords to be paid. Data has shown the success of these programs. The loss of housing is extremely detrimental to families. They lose connections to resources, community supports, family ties, education for their children, and finding new housing is extremely difficult. I am concerned today with some of the comments that I heard about the speed and slowing down of this process. I would ask the court to really consider whether or not speed is what we want in these cases or access to due process for both parties involved. I would also like to take the last minute of my time to talk about the clients that we serve. I'll give you two case stories that I have from clients that we have represented here at Legal Services of South Central Michigan. We represented a mother of 4 who had recently lost her husband. She had fallen behind in her rent after experiencing delay in unemployment benefits. In the initial matter, Legal Services was able to assist with entering a conditional dismissal that allowed the landlord to be paid rent. Prior to these months that she had prepaid rent expiring, the landlord again attempted to file a termination of tenancy case. We were able to catch that case at a pretrial, file an appearance, and get that dismissed since the landlord had already been paid rent and was attempting to evict her before that time was up. We also represented a disabled veteran after he was served with an order of eviction. He had been defaulted after failing to appear and did not recall being served with the original matter. Our client was also a single father going through a divorce and needed his housing to effectuate his parenting time. We were able to work with the landlord to get payment for rent, and he was able to keep his home and his parenting time. These are the tenants that we see and we serve. These are not difficult tenants. They are not deadbeat tenants. They are not trying to make living environments uninhabitable for other tenants in their residences. They are real people in very difficult situations. These cases move extremely quickly compared to our other cases. Our clients wait years for Social Security benefits. They wait months to get unemployment benefits. We're asking the court to make these small changes to enable them to have due process. Thank you.
So, counsel, I have a question for you, and and you do such great work. And honestly, I really appreciate whenever you give a human perspective to it. I think it's incredibly effective. But I just want to, go into this one point. I totally hear what you're saying about, these are good people who are facing really challenging times. Let's take those people aside. We're not going to address those people. How do you want to address the situations that develop when you really do have a problem tenant, a person that is highly problematic, that is creating disruption, and that is making it difficult for the other tenants? And, this is something that is a problem. It does happen. And I'm just going to tell you from personal experience, I had to move because of that situation, because that happened to me personally. I had to literally move out of a building I had lived in for 22 years because the tenant had become so problematic that I had to move. The quality of life had become so problematic that there was no way for me to remain there. So you have to recognize this is a real problem. There are genuinely, innocent, good tenants who do have disruption by tenants that are highly problematic in terms of their behavior, conduct, and disregard for other people. And I just want to ask you, how do you want to address that issue? Is this something that you want to ignore, or is this an issue that you want to take on because they're going to fall into the same problem or same issue of eviction? If you delay and delay and delay, then that does create problems for innocent tenants who really are going through a difficult time because of a problematic tenant. How do I address both of these issues together?
Thank you. And at first, I'll start by saying I'm very sorry that happened to you. That is a difficult situation for sure. I guess I would hate to overly emphasize that situation as opposed to what we see in court every day, which is really not difficult tenants, but it's tenants who have fallen behind in their rent. And so to prioritize that situation over the majority of cases that we see, I think would be difficult. I do think there are protections for tenants who are dangerous tenants or a health hazard. There are rules for that, and these court rules would not change that process at all. And so I think there are protections for those types of situations. We're asking the court to adopt these rules.
But counsel, wouldn't they get caught in the same problem, right? Let's say you have a really difficult situation in a building and the landlord wants to take action or something needs to be done. They're going to fall under these same protections. What I'm saying to you is, I understand, and I respect your argument. If your argument is that, look, that's unfortunate and we have to focus on the larger pot of people or pool of people, that's a very respectable, understandable argument. I'm just trying to ask you to address the issue that does happen with these really problematic tenants. If they wind up in the same situation, how do you address the innocent tenants whose lives are really upheaved as well?
I think there are abilities to file under a health hazard if there's a dangerous situation for a landlord or other tenants. And I guess I would refer back to some of the comments I heard about some of the criminal rules that were being proposed this morning. We have to have a balance in the court. We have to balance, the rights of tenants, the rights of landlords, the rights of neighbors. And what we are asking for is not a huge delay. I think a lot of the delays that we're seeing in courts right now are due to process issues, not this court rule. We have resource issues in a lot of our courts, especially our smaller courts, and this rule doesn't change that. And so even if you have the same situation you're talking about, the resource issues are still there. The delays are there that are not caused by this court rule, but just because of the amount of evictions, the amount of expungements, the amount of civil litigation, debt collection cases that district courts hear. Those delays are there. What we're asking for is the ability to continue to represent clients, to continue to advise them of their rights and hook them up with resources that actually benefit landlords. And we feel this court rule does that.
Thank you, Council.
Thank you.
Thank you very much, Council. Thank you for being here. The next speaker is Kelly Foster. Kelly, you may proceed.
Thank you, Your Honor. I'm Kelly Mackey Foster. I am the Director of Detroit Eviction Prevention at Lakeshore Legal Aid. I'm also a board member of the Michigan Coalition Against Homelessness. I think it's noteworthy that we're here during November, which is Homeless Awareness Month across Michigan. We heard some statements earlier about the need to return to bulk processing and speed. Disregards the fact that each one of those cases represents an individual or a family, and the impact on their lives is dramatic to them and to their communities. I've been a housing attorney for 15 years. I've practiced in many jurisdictions in Michigan, including mid-Michigan and Detroit, but now the focus of my practice is in Detroit itself. On behalf of our staff, I submit support for all of the proposed amendments. We've heard opponents say that courts are not equipped to manage changes, that it will impose too much of a burden on landlords, and that cases will take too long. I would draw the court's attention to the comments that were submitted by the 36th District Court in Detroit. The 36th District Court is the busiest court in Michigan and one of the busiest in the country. Before the pandemic, they processed 30,000 eviction cases every year. And just yesterday, there were 376 eviction cases on the docket. 376 distinct cases in one day. No other court is better positioned to talk about volume challenges than the 36th District Court. And what they have said is that this may cause some additional challenges to the court and personnel, but we believe those challenges are nothing compared to the challenges that our constituency will face if we ignore the needs of our litigants, both tenants and landlords. I acknowledge comments that have been made that there's an affordable housing crisis, that there are implications that are related to funding and systems. But what these amendments do is address the need for access to justice in our eviction courts. The amendment to 4.201B3C adds language to the complaint that the property is in compliance with applicable state and local health and safety laws. The amendments make clear that co-compliance ordinances that are in place for safety will be enforced. We talk to over 120 new tenants in Detroit every single week. Every single day, I hear instances of tenants who live in deplorable housing conditions that do not come close to compliance with the duties of habitability, good repair, or local code compliance requirements. The most frequent substandard condition we hear is a lack of heat. Not having heat in Michigan during winter is unacceptable. But we also hear about bugs and rodents and sewage in basements, exposed electrical wires, collapsing ceilings, unusable appliances, plumbing in bathrooms that do not work, and lead paint that is poisoning children. The remedy for noncompliance is dependent upon the language of the local law. Requiring a pretrial puts evictions in line with all other lawsuits in Michigan. The amendments lay the framework for ensuring due process and access to justice. And I see I'm out of time, so I will yield.
Thank you very much. Thank you, Council.
Council, I have a
sorry, go ahead.
I just have a couple of questions. You said your practice focuses on the city of Detroit. Do you agree with the statements made earlier by others who practice in the 36 district courts that it's taking many months to resolve landlord-tenant cases?
Yeah, I do agree. I think that the problem and of the issue regarding how long it's taking is absolutely needs to be addressed, but I believe that's addressed through funding and systems change. And what this rule and the amendments are about is access to
Let me just
justice.
jump in because I don't really know what that means. I mean, that assumes that funding is just available and we just haven't turned on the spigots yet. I mean, if there was funding available, presumably it would be, they would have that funding. If staffing funding was available, we have the Wayne County Circuit Court is in crisis mode because they don't have enough clerks to conduct jury trials. We have criminal defendants who have waited up to 5 years in the county jail to have their trial in Wayne County. So this assumption that there's funding out there and we just haven't turned on the switch yet doesn't seem to me to be a likely thing to happen in the near future. You mentioned due process and access to justice. And what concerns me, I think courts are supposed to be impartial and are supposed to be fair to both sides in disputes and adjudicating disputes. And there seems to be a lot of delays in this process, I think occasioned by a lot of the rule changes that this court has made over the last 2 years. And it seems to me that one side in landlord-tenant cases bears all of the expense and increase in damages from these delays. And so when we talk about due process or access to justice, aren't landlords entitled to have access to the courts and to have their matters adjudicated in a timely manner? Or, I mean, is it fair to think that they don't have access to justice right now in Michigan either?
So I believe that the landlords and their attorneys do have access to justice at this point. I acknowledge that it does take a long time right now for the rental assistance processing to happen through the SARA program. And so that's part of what some of the delay actually is related to. I recognize there's not like a pile of money sitting held somewhere to make these changes, but I believe that tenants should have the same rights that the landlord does, which means access to counsel, right? And so our ability to represent tenants under these parameters of the amendments has increased.
Well, I get that in terms of having the assistance of counsel, but the whole process is set up to adjudicate disputes. And, you know, we used to say justice delayed is justice denied, but that's apparently not a thing anymore in Michigan. The problem is adding more rule changes that increase the delays in the current environment. It's just not good enough, at least to me, to say, well, then find some funding to deal with it. Because it's not, all we're going to do is mire the process. It's going to break down, melt down even more than it already has, because we have high-minded aims that are laudable and important in society. But if we keep doing things without thinking about the impact that it has on the operations of the court, then all we're doing is really destroying the system and its ability to function for all litigants. So anyways, I'm giving a speech now, so I'll stop. Thank you for your
No, it's okay. I mean, you're raising, I think, valid and fair points. And I just believe that tenants, because they live in Detroit, should have less opportunity to raise claims and defenses than someone who lives somewhere else is patently unfair.
I agree, and I'm very
counsel.
sympathetic to the conditions that you're reporting on people, and obviously to people who are, anytime someone's evicted, it's a very unfortunate and sad circumstance. So as Justice Bernstein mentioned, I appreciate the work you do to try to mitigate and avoid that outcome.
And I'm just going to ask one very, very quick question. But it's just because I just don't think this question's really been answered. And I think we've heard a lot of people and we're, trying to balance everything. But the one question that it just kind of keeps coming back to is, and I think to Justice Viviano's point, is what do we say to, again, the small business owner, let's just say the person that rents their house, right? Is it just, what I guess my question back to you is, and I just really would love to get an answer to this. What do you say to the person that's just renting their house as an investment? A person is there, they're not paying the rent, you have these continual delays, and they can't make their mortgage payments. What is it? How do we balance that? And that's really what I'm trying to do right now.
Yeah, and I think that is fair, but keeping in mind that landlords are running a business, right? And they're voicing concerns because this is going to reduce their ability to make money. Being a landlord brings with it responsibilities and duties that they have. And so my position is, if those duties are too burdensome to comply with the law, I think perhaps they should not be a landlord.
Okay, thank you.
Thank you, Council. Next is Brenda Sheard. Brenda.
Yes, hello, court. My name is Brenda Sheard. My situation is different. I've been on the phone ever since you began, and I still haven't heard anyone that paid the landlord $3,000. And got evicted. I am 72-year Detroiter, intended living with a disability. I received a default eviction judgment 2 days before Christmas without my knowledge. I didn't know I was being evicted because my landlord, Yolanda Lockhart, tore down my mailbox. So I never knew, because I've never been through this before. So the mailbox was tore down. So I don't know if the mailman never, sent the mail or not. I borrowed that money for my kids that I got to college, all four of them, after my husband died. I never experienced this. She broke in at the time I was I paid her $3,000 to move in. She broke in, stood over me. She had a gun box down, and she cussed me. I was asleep. It scared me so bad. I was homeless for 7 months. I just got at the senior Morton apartment. And so what about the landlord that doesn't follow the rules, the law? She took my $3,000 that my children gave. They live in Atlanta, so they doesn't live here. And all this money to lady, and one knows that the man really gave her too much. But this was her time, and because she thought I was by myself, a disability.
Ms. Sheard, your audio is kind of cutting out. We're losing you a little bit.
I'm sorry, maybe. Oh yes, I'm sorry.
That's better.
I spent 7 months homeless, and that was not my excuse. Then I paid my rent, and this happened to me because me do for people like that, because that's evil. She like, oh, she good pray. And my kids sent me that money to pay her. She wasn't following the law. Like I said, the mailbox was tore down. I didn't know nothing about eviction. Someone could come and knock on your door and set your stuff on the sidewalk. The roof had a hole in it. She camouflaged a lot of stuff.
Ms. Sheard, your time is up. Thank you very much for your comments, and thank you for being here today. Thank you. Next is Jeremy Piper. Jeremy.
Good morning. May it please the court. My name is Jeremy Piper. I've been a licensed attorney in Michigan since 2001. My office is based in Flint. However, my practice of representing property owners, mom and pop landlords, and management companies is statewide. We handle summary proceedings in over 50 district courts on a regular basis. I'm opposed to this proposed amendment to the court rule and have submitted a detailed written comment last month. The reasons why this proposal is wrong are numerous and obvious. What is not clear at all are what are the reasons for implementing the amendment. The proposal itself simply states that the courts will be dealing with the effects of COVID for a long time. This should not be sufficient to justify such a significant and catastrophic procedural change, a change that will and has, under the emergency administrative order, caused massive stress on the district courts, judges, and staff, including the legal aid offices. I witness firsthand on a daily basis how these rules have pushed clerks in the courts to the breaking point. Mundane summary proceedings have become hostile and contentious, not just for the parties, but for the judges, the clerks, and the officers tasked with implementing them. The SCAO should have data on the negative effects these emergency orders are having on the court workplace, not to mention the huge costs associated with thousands of totally unnecessary adjournments and other delays. These problems are not a lingering effect of COVID. They are a direct result of Emergency Administrative Order 2020-17. Making these rules permanent will not solve this. Other reasons offered in support of the amendment appear to be political in nature. Court actions to enforce rental agreements are designed to keep tenants in their residences. They are not part of a nefarious eviction machine. Landlords do not want empty units. As many have stated, including numerous jurists and well-regarded attorneys, this amendment alters substantive Michigan law. Rental agreements are based in the underlying state law and the established enforcement mechanisms. The courts should not legislate through administrative rule changes. This debate and responsibility belongs to the legislature. Thank you for the opportunity.
Council, I'm just going to take a liberty. I'm just going to ask a question just because I'm just trying to get an answer to this, and I want to get it from, I mean, I've asked it twice of people who have opposing arguments to yours. So the answer I'm getting, and I'm going to ask the question now to you, the answer that I'm getting when asking a simple question as it pertains to the small business owner who is renting a house that basically they're not, this is not their main business. They're just renting a home or a part of their home or whatever it is, second home or whatever the situation is. And they're not able to pay the mortgage because there is a person that is not paying. This is being dragged out for an incredibly long period of time. The response I've seen to be getting, and like I said, I asked it twice, so I'm going to like to hear it from you, from your side. The response I seem to be getting is, well, then you shouldn't be a landlord. And I'm just trying to think about this. I don't know any other business that you would go into where you should go into the business with the expectation that you're not going to get paid. And that if you don't get paid, it's your problem. That seems to be the response that I'm getting, and I asked it twice, which is for the small business person that's literally just trying to rent out a house, that, if they're not getting paid, now they can't pay their mortgage, now they can't pay their costs. And the response back seems to be somewhat unsympathetic to the point of, well, then you just shouldn't be a landlord if you're doing this, because you should just expect that you're just not going to get paid and that you're not going to be able to seek any type of assistance from the court system.
So thank you for that, Judge. And I have heard you ask that several times. The answer to the question is something that happens a lot of times in Flint. It happens a lot of times in Detroit. And the small landlord is unable to pay the taxes. And eventually the home is foreclosed, or they're forced to sell it to out-of-state investors. This happens all the time. And so the municipality loses the tax revenue. The home gets depleted in terms of maintenance, deferred maintenance, et cetera. The other situation, which goes to your other question, is what happens when you have a very bad tenant, like you had in your situation. Under these proposed rules, what will happen is that your next lease will be a month-to-month lease. And that's because the landlords will be forced to modify their lease structures to allow them some degree of security going forward to enforce them. I don't know if I answered your question or not, but the reality is that the mom and pop landlords are going to go out of business.
Council, thank you. You did. Thank you.
Mr. Piper, this is Justice Viviano. I just have a question on a slightly different topic. And you mentioned you practice in a lot of different courts, and we've been focusing on the 36th District Court. And I don't want to be unfair and only focus on one of our district courts, because I think there are others, and we've sort of heard it alluded to that there are others who have significant docket backlogs in the landlord-tenant area. I'm just wondering if you can share with us are there other courts? Is that true that there are other courts that have case backlogs?
Yes, nearly every single court that we practice in is on a severe backlog, and it's probably a staffing issue. It's these multiple adjournments, the amount of paperwork that these courts have to generate. Prior to COVID, a court clerk had to touch a file 17 times to process one summary proceeding case. Now it's got to be in the near hundreds. And so, yes, it's statewide.
Okay, thank you.
Piper, I
Thank you.
actually have a question. I'm wondering, have you practiced in any places that have eviction diversion programs?
Well, yeah, I mean, there's eviction diversion programs in some fashion all over the state.
And has that impacted your client's ability to do what they need to do to protect their rights?
Well, it depends on the structure of the eviction diversion program. The main component has been the conditional dismissal, which started out as a mechanism to avoid a Section 8 tenant from being terminated. And it's now morphed into a mechanism for multiple months of delay and requiring landlords to go back to court on motions for evictions and whatnot. I think eviction diversion programs are helpful as long as they're timely and they follow the court rules.
Okay, thank you.
You're welcome.
Thank you, counsel. Thank you for your comments and answers to our questions. Jay Offen and Rena Eagle are not here. The next speaker, therefore, is Kristen Lordy. Kristen, you may proceed.
Good morning, justices. Thank you for hearing my comment. I'd like to start by personally thanking Justice Bernstein and Viviano for their questions. They're greatly appreciated. Justice Bernstein speaking to the small business owner, of which I am such. I really appreciate that. I am a landlord in the Upper Peninsula, and I own and rent single family homes. I'm a small single proprietor, woman-owned business that started in 2011. I'm adversely affected by the rule changes. Prior to recently, just in September, I had not needed the courts during the pandemic, so I hadn't personally experienced the rule changes. I've been able to work out issues with tenants. They've been able to pay, and so I just hadn't understood the impact of these changes. Recently in September, I had a situation where a tenant breached the lease terms and then refused to vacate the home upon a 30-day notice to proceed or to negotiate a remedy. Going through the process has been an alarming experience, and it does not adhere to the summary proceedings, of which there's a great write-up by Peter Riddell that I really appreciate. It says, Summary Proceedings Act was intentionally designed to eliminate delays inherent in litigation and create an efficient judicial process to replace the common law remedy of self-help. While waiting for the numerous court dates and delays, I am prohibited from regaining possession of my property and from providing housing to a suitable tenant that will follow the lease. Additionally, due to the current hostility with the tenant, my property incurs more risk of adverse impact due to the current untenable situation with the current tenant. In short, the state of Michigan is prohibiting me from fairly managing my business and protecting my investments. I agree with the comments that were submitted by Mr. Riddell, the written comments. I also agree with the spoken comments by Matthew Palletz, Judge Mike Carpenter, the concerns raised therein. And in listening to all this, I mean, it really has me discouraged. My lease becomes unenforceable. I'm a very meticulous tenant. I write good leases. It becomes unenforceable under the current rules. And the idea that the justices are going to intervene in this substantive way really has me reconsidering whether or not I should be providing this service to the local community, of which the small business owner does provide. I'd like to read the last sentence, 2 sentences by Mr. Riddell, who stated the proposed amendments are unduly burdensome, unnecessary, and excessively favor the tenants in breach of valid lease agreements. The AAM implores the court to resume the pre-pandemic procedures governing landlord-tenant cases rather than adopt the proposed amendments and permanently slow the pace at which housing providers can repossess leased premises from defaulting tenants. It's very concerning. So, and the small landlords are not well represented here. Thank you for the two justices that are taking the time to ask questions and make valid arguments on behalf of small business.
Thank you very much. Thank you for your comments. Next is Dwayne Lobestall. Mr. Lobestall. Okay, next is Jarrett Levine.
Well, good morning or good afternoon. May it please this honorable court. I'm Jarrett Levine. I'm an attorney in Farmington Hills with Swistak and Levine. We represent owners and management companies and landlord tenant cases throughout Michigan.
Mr. Levine, I know we have a long docket, so I'm going to ask questions before the 3 minutes gets up so that you can actually answer the question within that time frame. Mr. Palance and Riddell and Ms. Lowe, I think, and a few others have told us about the benefits of Zoom hearing. Mr. Miller states that Zoom hearings do not help at all. They in fact delay the process and inhibit the process for landlords. Can you tell me where you fall in this array between whether we should have Zoom or not have Zoom for these types of proceedings?
I fall somewhere in between. I see the benefit and use of Zoom for access, especially in the out-county courts up north where the drives are long and it can increase access to the justice system. I see a benefit. I also see benefits on certain types of hearings, but it's not working in every court. And for whatever reason, it doesn't always work. But what I find is where it doesn't work, you can call the court and you can ask to be in person. And the courts will welcome you in person for the most part, not every, but we'll welcome you in person where you want to be and let you come in. So we're in person in some courts where Zoom wasn't working and we're still using Zoom. I see the access to justice and the ability for tenants to access the justice system, and also for landlords to not be hit with a big bill for a 5-10 minute hearing that's an hour drive away. And I can tell you personally that I'm billing clients less but doing more on certain Zoom hearings. And I can also tell you that it doesn't always work. And I think what Mr. Miller was referring to was the bulk dockets, and some courts have it figured out and some don't. And it would really benefit the court for further review to see what's happening. You purport to be one court of justice. You have a slogan.
I don't want to take all your time. Would you favor Zoom as the default and the parties have to ask for an in-person hearing, or would you leave it to the discretion of the trial court the other way, where in person is there unless the court says we're going to do Zoom?
I would say the default should be up to the parties. It should be up to the parties,
not the court. To the parties.
It should be up to the parties, and I believe that's
how party wants Zoom and another party does not. What should the court do?
The court should allow the parties to be in person. If both parties don't agree to be on Zoom, then the court should have the parties in person. Absolutely.
Thank you. And I'm sorry I took up almost all your time.
Thank you. So I was saying that we're one court of justice and justice for all. But I want to tell you a quick story, a true story. I represent a widow.
Mr. Levine, let's make it real quick because you're already at the end of your 3 minutes, but just
real quick, we followed your direction. Our clients have followed your direction. They're hurting. Mostly the mom and pop shops are hurting the most. I have a widow who's a client and she depends on income from one small community that she has in Metro Detroit. She inherited from her late spouse. The family has owned it for generations. She depends on the rental income. It's not flowing as usual. Is this justice for her? If you truly believe in justice for all, and you believe in one court of justice, you'll vote no, and you'll allow for further review. I'd be happy to be on any committee, any such committee. Thank you.
Thank you very much. Next is Constance Barron. Constance.
Can you hear me?
I can, yeah.
Wonderful. Thank you for hearing my point of view. I am, as the other lady was, a small landlord in Michigan. And I'm against the COVID-19 things becoming permanent. I think that the delays hurt, especially us small landlords. One of the things that has been brought up is the tenants needing more time, but these tenants are all adults and they have all received, they all know their rent is past due. It's not a surprise to them. And most of us small landlords, at least, really try to work with our tenants. We don't want to evict them. We want to keep them in the homes. So like me personally, by the time I'm evicting someone, I'm already tried to work with them. I've tried to encourage them to seek rental assistance if that's what they need and all that. And then we go to court and they just adjourn it when this person has either can't get any rental assistance or has not made any effort at all to try to help themselves. And that hurts us as small landlords, and it makes it to where I can't rent it to someone else. And I had one recently where the tenant actually turned the power off and moved out. And then when I went to the eviction hearing, she showed up and just said, oh, I'm going to try and get rental assistance. And they adjourned it. And she wasn't even living in the house. So these kind of things are happening when we're saying this is the way it has to be every time. I don't know if I have a clock on here. I can't see one if I do.
You have 48 seconds left if you have more to say.
Okay. Okay. So I personally think that dealing with these things in as efficient a manner as possible is better for everyone, both the landlord and the tenant and the court. It costs everyone more money if it takes longer. It costs me more money in attorney fees and court fees. It costs, it ends up costing the tenant more money because if they can't pay the rent, it just makes them owe more rent and it makes it harder for them to catch up. And now they have an eviction on their record. And especially if we have an issue where it's not non-payment and they're still adjourning them, even though it's not a non-payment issue. So I guess if anybody has any questions, that'd be fine. Thank you for hearing my opinion.
Thank you very much for showing up and waiting to all this time. We appreciate it. The next speaker is not here, so we will hear from Maya Aronoff next.
Hi, good afternoon. I'm a tenant in the Detroit area. And I had prepared some remarks, but I'm just going to speak from the heart. So I apologize if it's a little disjointed, because really listening to a lot of the comments from especially larger landlords and their representatives has made me want to tear my heart out. The way that we're talking about efficiency, moving through the docket, the need to process as many cases as quickly as possible because it's difficult for us to get through. Those are people. That's us as renters, and the stakes for landlords and renters are so different. For especially a large corporation, which is most of the landlord ownership here in Detroit. The stakes are maybe you don't get as high a return on your investment as you did before. For a tenant, the stakes of being evicted are not only being out on the street, but being potentially trapped in a cycle of poverty because now you have an eviction on your record and everything, as people have said from their own experience or their clients' experience, jobs, schools, everything comes from that. So to talk about it in this sort of removed way, as though efficiency is the most important thing that a court should consider is just so heartbreaking to me. And we're not even talking about that much extra time. We're talking about, 2 weeks to apply for rental assistance? And I have so much to talk about, so please ask me questions if I run out of time. But a lot of the evictions of people I know, people who are facing eviction orders, are not these crazy situations. It's one, they can't pay rent because wages aren't rising with the commensurate cost of everything else in this country, and large corporations are buying up all the housing from individuals who foreclose. And so nobody can afford the rent that's skyrocketing anymore. So that's a problem of income inequality in our country. And the solution to that is not to give tenants less time to apply for rental assistance. Or there's a lot of retaliatory evictions where big landlords have decided that it's cheaper to evict a tenant, it's faster to evict a tenant than it is to actually make repairs in their building, than it actually is to pay their blight tickets and to pay their property tax. Those are two huge issues. And this is such a drop in the bucket of that power dynamic. And to see landlords say, well, my business is going to fail if I have to wait 2 more weeks for someone to apply rental assistance, if I have to assert that I'm complying with safety laws, to me, then you're in the business of bodies. You're in the business of putting people out on the street. And to small landlords, yes, it is a different story. And I do hear those concerns. And I am lucky enough to rent from someone who is a homeowner, a working class homeowner who's renting out their bottom floor. My aunt is a retiree who depends on rental income. But you know what those folks would never do? Go to eviction as a first resort. Those folks would never go to eviction court as a first resort. They would hold my hand, apply for the rental assistance with me, rather than evict me out onto the street. And that's something my aunt has done for tenants in the past. And when there is an untenable tenant situation, which absolutely does happen in a minority of cases, and it can be awful, and that happened to my aunt, someone who is being very destructive. So what did she do? She told him 6 months ahead of time, I'm not renewing your lease. She helped him find an alternative living space. And then he was out of her apartment. And yes, not everyone can do that. She didn't have to do that. She could have had him on the street in two weeks where she was.
Is there enough? Your time is actually up.
People in the business of providing housing, of providing shelter, which is vital to all of us as human beings. You have to hold yourself to a higher standard. Sorry. Yeah, I know.
Yeah, sorry. Your time is up, but we really appreciate your comments, and thank you for sticking in here all morning to talk to us. Thank you for being here. Thank you. Next, we'll hear from Marie Reimers.
Good afternoon, Justices. My name is Marie. I'm the Vice President of the National Lawyers Guild Michigan chapter.
Your audio is cutting in and out, Ms. Reimers.
Yeah, it is.
Okay. Do you have a?
Would it be possible for the court to pass so that I could get headphones? Can I go
ahead?
on?
I'll call the next speaker and I'll come back to you. Yeah. The next 2 speakers on our list are not here, so we'll go to Ed Constable. Ed.
Hi. All right, I think I'm on.
You're on.
All right, so I'm president of the Genesee Landlord Association, which is an organization made up of about 300 mom and pop landlords. Most of our members have somewhere between 1 and 30 single family homes, very few multifamilies. And as an organization, we are against these changes, but we really feel like the changes make us and their position us as the slumlord, with our only goal is to evict, whereas our only goal is to try and provide housing and it stay occupied so we can make a little bit of cash flow in the process. If tenants don't pay the rent, many of the landlords I know have mortgages on these properties. In no case have I seen has any municipality ever been waiving the property taxes on any of these things while the government tells us we can't collect rent. And we also have insurance we need to pay. I'm going to skip through some of this stuff because some of it's been talked about many times, but we just had a case in Grand Blanc where we had a tenant that rents $2,000 a month and we accepted Sarah funds. She was into us for $6,000 by the time we finally got paid, so 3 months. We finally got the money. She then communicates with our office that she actually had the money the whole time and was just taking advantage of the system to get the free money. So she then pays 2 months rent after the fact of the Sarah, and then tries to do the same thing all over again. So now that we know, like she works full time for GM, making 80 grand a year. So now that we know that she's actually working the system, we say, we're not accepting Sarah funds from you. She shows up to court for the eviction case and says, I've applied for legal assistance, even though we've already provided her in writing that we're not going to accept assistance, and automatic 30-day adjournment. So by the time we finally got that tenant out, she owes us $8,000 in back rent, and the house is trashed. She's living in it with a pet that she wasn't supposed to have there to begin with. And so we're against these changes. Most of these landlords only make $200 to $300 per month per unit. And so one tenant who decides not to pay the rent can wipe out the profit of a single family home for years to come. Many of our members are retired and rely on the income of these properties. Some of them just have 2, 3, 4 houses that they're like. Genesee County has a lot of GM workers, and a lot of these GM workers would buy, one house every few years. They'd save up, they'd pay it off, they retire, and those, that $700 a month rental income, $300-400 a month profit, that's what they live off of, and in addition to their Social Security and potentially pension payments. So when they don't pay, it's been devastating for some of our local small landlords. And as I believe Jeremy Piper said, we're selling it to out-of-state. A lot of them are forced to sell to out-of-state investors. The biggest solution when people come to our meetings, like, what do we do? And the answer is California, because that's the only place you can dump them to. And when they get dumped to California, they don't get maintained, and the quality of housing stock continues to diminish.
Thank you, Mr. Constable. Thank you for your comments. Next, we will hear from Jeffrey Captain.
Hello, and I want to thank the court for making this process available to the public for comment. I'm Jeffrey Captain. I'm a current board member of the Apartment Association of Michigan and a past president. I'm also president of Captain Communities. We're a family business. My father started 58 years ago. Tells my father, myself, my sister, and cousins are all part of the business. We believe in providing quality and affordable housing that residents are proud to call home. This is a responsibility we take seriously. Our philosophy is we train our staff to support our residents. We're dedicated to provide service and support for our residents, and we offer a safe and clean community that stands tall, providing a home to the families residing in our communities. For almost 60 years in business, we've relied on timely payments of rent as critical to keeping qualified and motivated staff, and to pay various local vendors who provide maintenance and other services and allow us to keep our property standing tall for our residents. The goal is to keep residents in place and to minimize turnover. Turnover costs money for all. Turnover creates stress. This affects everyone. The average rent in Michigan is $900. We've consistently found that when a resident owes 1 to 2 months rent, they can recover. They can work off the back rent. We can figure it out. When it becomes 6 to 12 plus months of rent, it's beyond the point of no return. $1,800 becomes $10,000 or more. It's disastrous for residents. This doesn't help homelessness. It fosters it. This focus should not be on lowering default judgments, but lowering eviction. How do we make the system better? How to make it less stressful, less costly, and less onerous on all stakeholders? First of all, the financial strap residents, many who are left after the process with crushing debt, which weighs on them for years, affecting their ability to find additional housing and increasing wage garnishments on their income. And as Justice Bernstein alluded to, the rule-abiding residents who are good neighbors and follow the rules and are subject to problem residents who cause trouble but are unable to be removed timely. We just had this at a property where a resident was causing all type of vandalism, and it took us over 10 months to get them out of their unit. Property owners, another stakeholder, many who are small owners, also as Justice Bernstein alluded to, who are on the margins and are trying to supplement their wages with additional income. The irony is that leads landlords make up a greater percentage of diverse members of society who are trying to start a business and increase their income. Owners are unfairly being required to shoulder the burden that the public should share collectively. And the courts, which are clogged and unable to keep up and deliver the needed justice for owners, residents, and families. So what can we do? In working with my colleague, Hanan Les, and other members of our apartment association, we feel, one, let's make sure the residents understand their rights and options for help and assistance earlier in the process via notices, pamphlets, a robust public website with info that's easy to navigate. Number two, provide better access to legal representation. This can be accomplished by funding legal aid and different options that are available to residents. And number three, provide resources and oversight to district courts to maintain the consistency in the court process. Some courts, as you've heard, some courts can process a hearing in the 10 days required or have been able to in the past within the statute, but others take 3 to 4 months to process the first hearing.
Thank you, Mr. Captain. Your time is up. Thank you very much for your comments. Thanks for being here.
Thank you.
Next, we'll hear from Leslie Etterbeek. Leslie.
For allowing me to speak. I'm kind of a nervous public speaker and a very passionate apartment manager. I'm not a small apartment management company. I'm a female-owned business, but I manage over 10,000 apartment units in Michigan for over 36 years. On the onset of the pandemic, we vehemently and passionately worked with our residents to help them get federal funding, local funding, help them pay rent, stay living in our communities. We helped over 700 residents get over $3 million of funding. We are going to continue to do this, but I'm just going to talk about the everyday effects it's having on the communities in the management area and for the residents and the landlords and the communities that themselves. And we feel that the continuation of the COVID court policies will exponentially harm the residents and the landlords and the properties. In some of our communities, 20 to 25% of the residents aren't paying their rents. And they haven't been paying their rent for 8 months to 14 months. Again, like Jeff Captain said, in past days, we would deal with them on a personal basis, make payment plans. Now the increasing number of the environment of the renters that just aren't paying, not related to the ability to pay rent, but just to inconsistencies in the court policies, delays, adjournments, misuse of the system is hurting the residents that aren't paying their rent. And I represent owners that are investing in properties in other states into Michigan that have spent the last couple of years spending a lot of money on these properties. This year, it is now hurting their ability to put money back into these properties and improve the housing asset that the housing community. It's also causing us, this was addressed before, to hurt people that quality renters that can afford to pay rent, because yes, we are being harder on our qualifications, our initial security deposits, because we can't burden the 25% of the residents that are not paying us. So I just ask that the COVID, while we compassionately will help residents that and provide housing, we would like to see the COVID court policies not remain in effect. And thank you so much.
Thank you very much. Thanks for hanging in here all morning. Oops, sorry. Am I interrupting somebody? No. Okay. Next is Judge Demetria Brew. Judge Brew.
Good afternoon, Justices. I am Demetria Brew on the bench of the 36th District Court, and thank you for this opportunity. The 36th District Court Landlord-Tenant Bench supports the proposed amendment to MCR 4.201, and in some instances, asks this bench to provide greater time latitude. We support the proposed amendment for the following reasons. The size of our caseload far exceeds our colleagues in other jurisdictions. The magnitude of our caseload dictates how quickly we can hear and dispose of cases. An average year for us consists of approximately 30,000 cases or more, which equates to 4 judges hearing approximately 7,500 cases per year individually pre-pandemic. During the pandemic, 4 judges individually heard an average of 5,500 cases per year. And we've recently added a 5th judge where we're still hearing about 5,000 cases individually. That number far exceeds the annual number of landlord-tenant cases many other courts hear collectively. Our congested caseload necessitates our judges to ask this court for discretion for time beyond that which is set forth in the proposed amendment. To date, our dockets are already full, well beyond the suggested 14 and 30-day proposed limitations. As this court has recognized, the pandemic has and will continue to have long-lasting effects. And for the citizens of Detroit, the pandemic has highlighted poverty rates, lack of affordable housing, and other injustices to citizens on the margin of society. Because of the administrative order, these marginalized citizens have been afforded time to obtain rental assistance, find replacement jobs, move with dignity, and the right to counsel through legal aid. Furthermore, the legal aid attorneys need additional time to address these numerous litigants. The proposal does not give the attorneys who are short on resources the necessary time to answer complaints and prepare cases. Unless we are afforded the discretion to extend additional time for stays, lifting of stays, etc., the dignity afforded the litigants during the pandemic will disappear and they will return to assembly line justice. As an example of the need for assistance in Detroit, from March of 2021 through the present, the state SERA payout was just shy of $1 billion, and 1/4 of that went to the city of Detroit. The need for assistance is evident and requires additional time to process applications. Furthermore, both landlords and tenants benefited from the SERA funding. Finally, we would ask this court to amend the court rule to require plaintiffs to provide a deed and property management agreement as documents necessary to show plaintiff's right to possession. Thank you for your time.
Thank you, Judge. Thanks for hanging in here all day and for your comments. We really appreciate you. Thank you.
We appreciate you.
I'd like to go back to Marie Reimers. Marie, did you get your headphones? Are you ready?
I am ready, Your Honor. Thank you. I am here today as the Vice President of the National Lawyers Guild. We are an affinity bar association with over 500 lawyer members in the state of Michigan. We are here in support of the proposed changes Rule 4.201. Specifically, there's been a lot of things addressed today, and we stand in solidarity with the other advocates from legal aids that have spoken today. But specifically, I'd like to talk about two things. One is the proposed change to 4.201 B3C, the addition of the health and safety language in the complaint. As you've heard from advocates today, this is of special importance to many of our members who work in the city of Detroit and see conditions issues in several of in properties in the city of Detroit frequently. We think that the addition of requiring landlords to affirmatively plead that they are in compliance with health and safety issues will lead to greater justice for tenants in the city of Detroit. I'd also like to speak briefly to the delays that have been talked about by several commenters today. I'd like to look at specific delays are in the amended court rules, and those delays are at maximum a 30-day stay for a tenant to obtain rental assistance. We are talking about 30 days. Most court cases are not resolved in 30 days, but summary proceedings are. This is not an undue, transformative, or radical delay. It is a delay only for the purpose of getting the landlord the rental assist, the rent money that they are claiming that they are owed. I'd also like to talk about the delays that have been spoken to both in the 36 and other district courts that are claimed to have been results of Administrative Order 2020-17. The National Lawyers Guild disagrees that those delays are caused by the administrative order. Instead, what those delays are caused by is the fact that there is a rate of default in summary proceedings and in landlord-tenant courts. With the advent of Zoom court, more tenants are showing up to court, and therefore district courts and district courts are not entering as many defaults. There are more cases that are being heard. Prior to the COVID-19 pandemic, up to 43%, at least in the city of Detroit, and probably higher in our northern counties, of those cases were being resolved by default, which made the process move quicker. Now that things need to be heard, it is slowing down. But as we've heard from many commenters today, slowed down in summary proceedings, first of all, is not really slowed down. And also, it's worth it if that means that our tenants and our neighbors are accessing justice. So thank you for your comments, and please approve the rule.
Thank you very much. Thanks for being here. Thanks for your comments. That concludes today's administrative hearing. Again, we want to thank everybody who spent almost all of their morning to give us these comments. We appreciate it. Have a great day, everyone.
Oh.